in the review application
Yes, I did read that into the record.
brought by General Poison against the ANDPP on racketeering.
That's correct.
He wanted, or he approached the court to have the decision to issue out the racketeering certificates to be reviewed and set aside.
That's correct.
Now, let me take you back to the internal memorandum that we dealt with yesterday, which is contained in your annexure SB 211 111. And I specifically refer you to page 114, SB 2114. Are you there?
I am.
In the middle of the page, you will see a sentence that starts with NJ4.
I do.
For purposes of completeness, regarding what you'd be saying about this paragraph, just read it again into the record.
So it states, NJ4 is a statement of ire taken on 31 August 2012, following a consultation with the prosecution team. Whatever is contained in this statement was already information related to the prosecution team by the deponent during the consultation with the prosecution team. Therefore, the applicant's averments are unfortunate, unfounded, and misleading. This seems to,
Yes.
This seems to suggest that the information that was contained in the 31st of August statement was what was already related to the prosecution team before that date.
Do you want therefore to...
If we could remind ourselves, sorry, Counsel, if we could remind ourselves that the document I'm quoting from now is the internal memorandum as per 111 of the Cato Manor team to Lawrence Hodes, SC, with regard to the replying affidavit of Boyson.
Whilst you are still on the replying affidavit of Boyson, I want to refer you in a moment to the replying affidavit of Boyson, which I'm instructed that it is not part of the record. Madam Chair and your two sisters, at this point in time, may I ask for leave to hand up a copy of General Boyson's replying affidavit in the review application brought in the High Court in Durban, in KwaZulu-Natal. It will later be marked as an exhibit. We have prepared 3 copies for the panel, and I applied to hand them up as exhibits, as an exhibit. With your leave, Madam Chair.
Thank you, Counsel. Have you made
Copies have been made for Advocate Chauke's team, and we handed 2 copies to them. And a copy has been made available to the witness.
Yes, thank you, Counsel. This document, as you indicate, will be marked accordingly at the later stage as an exhibit.
That is so, Madam Chair.
The replying affidavit of Colonel Major General Boysons.
Counsel, if I may, for completeness, perhaps read the entire, not just the one paragraph that I have, but from page SB 2113, it says at paragraphs 19 to 21, perhaps for completeness and clarity, I should read from there, if I may.
At paragraph, which at paragraph?
It's on page SB 2113. At the bottom, the statement of ire at paragraph 19 to 21, referring to the paragraphs in Boyson's replying affidavit.
Let me remind you that yesterday, Madam Chair proposed that we use the even numbers. It's a duplication of 112.
Oh, okay.
Yeah.
Certainly.
Just stick to 112 because
Thank you.
it's the same statement.
So on page 112 at the bottom, it says at paragraph 19 to 21, referring to Boyson's replying affidavit. NJ2 is a statement of ire taken on 3 August 2012, stating the managerial responsibilities, participation, and interferences in activities of a section of the Durban organized, and I go to page 114, crime based in Cato Manor. This section, under management and supervision of the applicant, committed horrendous pattern of criminal activities. This statement, that is now referring to NJ2, was obtained before 17 August 2012, being the date on which the certificate was authorized. Clearly, they are dealing with what information was before the National Director at the time the authorization was made on the 17th of August. The document then continues. NJ4 is a statement of ire taken on 31 August 2012, following a consultation with the prosecution team. Whatever is contained in this statement was already information related to the prosecution team by the deponent during the consultation with the prosecution team. And this seems to suggest that this information, although not in an affidavit, was before the acting national director at the time of the authorization of the racketeering certificate.
Is that all that you want to comment on?
On this part, that's
on
correct.
This part.
That's correct.
Then let me take you to page SB 2118. And your attention is directed to add paragraph 29. But maybe before you deal with the paragraph itself, let me refer you to the replying affidavit of Johan Vessel Boysen and go to paragraph 29 thereof and read it into the record. Because this was a dealing with paragraph 29.
That's correct.
In the memorandum.
Paragraph 29 of Boysen's replying affidavit states the follows. I submit that the only reasonable inference to be drawn from the aforegoing is that none of the statements were in the possession of the first and second respondents when the impugned decisions were made. The statements of ire certainly could never have been in their possession by 17 August 2012, considering that by 11 August 2013, the statements were still awaited by the second respondent, NJ4 in brackets is in any event dated 31 August 2012. The same applies in respect of Danikas and Ndlondlo.
Now go back to SB 2118 in your bundle.
Advocate Mhlamyane, sorry, I think you lost us a bit. In the replying affidavit, which paragraph did you refer the witness to?
It was 29, I said.
Paragraph 29.
Indeed, Madam
Thank you.
Baloy-Mary.
Is that the portion that she has just read into the record? Because apparently before you went to 29, she was dealing with something else.
Before we went to 29, she was dealing with paragraph 112, which goes over to 114. And then I referred her to
Page.
the replying affidavit, paragraph 29 of this affidavit, the replying affidavit of Johan Wessel-Boysen, General Johan Wessel-Boysen.
SB 2118.
Yes, in SB 2118, Madam Chair, that's where the Katomana team were.
No, I just want to know whether you are
responding.
now referring her to SB 2118, paragraph 29.
Indeed, Madam Chair.
And before this, you were dealing with the SB 2114.
That's correct, Madam Chair.
Yes, thank you.
Go back to SB 2118, Advocate Batohi.
I'm there.
Proceed to read that paragraph.
At paragraph 29, the first and second respondent were in possession, I emphasize that, were in possession of the statements of witnesses referred herein referred to before 17 August 2012. NJ4 is a further statement obtained after NJ2, which was obtained on the 4th of August 2013.
Do you want to give a comment?
Well, not just to this particular paragraph. If we could go to the next one, perhaps I can comment after that.
Yeah, may I just
Then-
come? Yeah, may I just come in here, just to check, because I think when this paragraph was read into the record yesterday, a question arose as to who are the first and second respondents. And what I have on record is that it would be the acting NDPP Jiba, Advocate Jiba, and then the second one would be who? The public prosecutor.
That was yesterday, the evidence leader clarified that was Ms. Advocate Maema.
Okay, right, thank you.
May I proceed, Council?
Thank you, Madam Chair. You may now go to SB 1D 097, which is a statement of
I beg your pardon, Council. Advocate Batoi has just asked you to move to the next paragraph because she had no comment with regard to paragraph 29. Did you want to comment on paragraph 30?
No, Chairperson, I meant the next step in leading of
The
the
next
evidence.
step.
Yes, I may not have been clear.
Thank you. You may, Council.
Thank you, Madam Chair. Move over to SB 1D 097, which is the statement of Colonel Ayer previously marked NJ4. You can read the first sentence. Start with the names of Ayer and read the first sentence contained therein.
Give me a moment to go to the document.
SB1D, Madam Chair, 097, previously referred to as NJ4.
SB1D.
Indeed, Madam,
What page?
097.
Yes. Yes, thank you.
You may proceed to read the first sentence, but before you do that, you can read the names of the deponent.
Certainly. Chairperson, this is the statement that we have been referring to previously, the statement of R.S. Iyer. It's the one dated 31st August 2012, also marked NJ4, or referred to as NJ4. The first paragraph states, I am Colonel in the SAPS. On Thursday, 2012-08-30, so that would be the day before the statement was signed, I was approached by investigation team. I want to make additional statement as follows. I can now comment on that, Council.
This is an opportune moment for you to comment.
So if one looks, Chairperson, at the previous reference that I made to the, let's call it the Holders Memorandum at SB 2114, page 114. May I proceed, Chairperson?
Proceed, ma'am.
At that point, it states there that NJ4 is a statement of Iyer taken on 31st August 2012 following a consultation with the prosecution team. Whatever is contained in that statement was already information related to the prosecution team by the deponent during the consultation with the prosecution team. As I said, the suggestion here is that this information was available to the team and therefore to Advocate Jiba at the time she signed the racketeering authorization on the 17th. However, if one looks at the document we just referred to, and that's SB1D at page 97, the affidavit of Colonel Iyer, he states that he was approached the previous day, that is on the 30th of August 2012. That being the case, this information could not have been in the possession of the team as at the 17th of August 2012. Thank you, Chairperson.
Advocate Batohi, isn't it that this statement that we are looking at, SB1D at 097, the opening tells us that he was, the deponent was approached by the team, and now he wants to make an additional statement, meaning he had made a statement, but now he's making an additional statement. And it is that statement that maybe was before, it is that statement that maybe its content was already related to the team.
Chairperson, there is a previous statement, that's correct. The previous statement of Colonel Iyer, which is signed and which was before Advocate Jiba when she made the, when she authorized the racketeering certificate. So I don't understand your question relating to this particular statement.
Through you, I don't want to create a dialogue, if you allow me.
You may just ask the question.
After reading the opening of the statement, you made a comment to say, given that this was on the 30th of August, a day before the authorization was signed, it would certainly not, it would mean that Aya's statement was not before the acting NDPP when she made the authorization. But from the reading just of the opening statement, Aya tells us that I was approached on the 30th to make maybe another statement, because he then goes on to say, I want to make an additional statement. An additional statement meaning there was previously another statement.
We are in agreement, Chairperson, through
Okay.
you, that there was indeed another statement. The point I want to make, though, is that if one looks at SB 2114, it relates to the NJ4 statement that is dated 31 August. And it states that whatever is contained in this statement was already information related to the prosecution team by the deponent during a consultation. And my point being that he was only approached the day before to make this additional statement. And therefore, the impression is that this information was not before, not with something that the prosecution team had as at the 17th of August 2012.
Thank you.
Maybe to take it further, go to SB 2118 and tie what you are saying with what is contained in under Act paragraph 29, under subheading Act paragraph 29. Maybe that could assist.
I'm hoping, just let me read it again. The first and second respondent were in possession of the statements of the witnesses herein referred to before the 17th of August 2012. NJ4 is a further statement of ire obtained after NJ2, which was obtained on the 4th of August 2013.
Just a minute. Sorry to interpose, but maybe we need to reiterate first, who's the first and who's the second respondent.
First is the Acting National Director, Advocate Jiba, and the second is Advocate Mayema,
Proceed.
prosecutor. I'm reading it in the context of paragraph 29 again of Boyson's replying affidavit, so that I'm clear. It appears from what is in on SB 2118 that the first and second respondents were in possession of the statements of the witnesses referred to before the 17th of August 2012. And that's as far as I can take that.
Then let's move on.
Before you do that, Council, to get the sequence correct, because we seem to be getting confused, but I understand what you are saying.
Thank you, Chairperson.
And this paragraph, SB 2118, paragraph 29, seems to clarify the position. The only aspect that I want clarity on, Council, Advocate Batoir, is that the statement NJ4, which is dated, that is the additional statement,
That's correct.
dated 30th August 2012.
I think it's 31st of August 2012.
31st of
Chairperson.
August 2012.
That's correct, Chairperson.
Was the added statement to the earlier one of the first one.
That is correct, Chairperson.
And in paragraph 29, the team says they obtained that additional statement on the 4th of August 2013, which is a year later, correct?
My reading of that, Chairperson, is that NJ4 is obtained after NJ2, which was obtained on the 4th of August 2013. So NJ2 was obtained on the 4th of August 20. That's the way I read it. I'm not sure if there's a mistake, because the evidence that we have presented thus far is that the statements were both obtained in 2012, one on the 3rd of August, that's my understanding, I stand to be corrected, and one on the 31st of August, but both in 2012.
Which one says it was obtained on the 3rd of August? Where does it
It's
say
3rd or
that?
4th of August, Chairperson. The first one of Iyer, we can check that statement.
It is dated 3rd of August 2012.
Yes, that's my understanding, Chairperson. So I
Yes.
think there's an error in this memorandum.
Now, the memorandum says that NJ12, dated 3rd August 2012, was obtained a year later, 4th August 2013. When you look at paragraph 29.
This is what it says in this
Yes.
paragraph. That is correct, Chairperson.
And yes, that is what I wanted to ascertain with you. Is that how you understood it? In other words, the statements were then obtained by the team a year later after it was prepared, the NJ2.
Chairperson, that's not my understanding of what the evidence is. My understanding is that the authorization of Advocate Jiba is on the 17th of August 2012. And the statement of Iyer is dated, the first one, 3rd of August 2012.
Yes.
So, and the second statement is the 31st of August 2012. So I'm not sure, I can't understand. Perhaps the team can explain.
NJ4.
Yes, the team can explain what the 4th of August 2013 is intended to mean. But my understanding was that these statements were obtained in 2012, 3rd of August, and then 31st of August.
Yes. We will accept it for what it is. It is the
Yes.
latter part of that statement, recorder.
That is correct.
That NJ2, I beg your pardon, that NJ2 was obtained supposedly by the team on the 4th of August 2013.
That is what the
We
team
will-
has written. I agree on
okay.
that, Chairperson.
And if the recorder is correct, it means that as at 17 August 2012, the team had not had a sight of NJ4, which was an additional statement of Colonel Ayer.
That is correct, Chairperson.
Thank you.
Dated 31st August 2012.
Lead Counsel.
Thank you, Madam Chair. Let us then leap over and go back to page 64 of your affidavit. Are you there?
I am, Counsel.
Paragraph 151 has already been read into the record. You don't necessarily have to read it again,
Thank you.
but you can then deal
I beg your pardon, paragraph?
151, Madam Chair, at the bottom of page 64.
Are you back to her statement?
Back to a statement, Madam Chair.
Paragraph 15?
151.
151.
Yes, 151.
We have gone back to those paragraphs. I thought that we were at 154, but it's fine. You may proceed.
I just wanted to draw her attention, Madam Chair, that she has already read into the record paragraph 151, where you refer to the Gauteng J judgment.
That is correct.
When was the judgment delivered?
My understanding is that it's in February. I need to refer to the judgment to get the date.
Maybe let me
If
assist
you can help me, I'll appreciate.
Yes, I don't have in my possession the bundle itself, but my instructions are, it is contained in CL1, Madam Chair, on page 000352.
Please repeat that. C1.
CL1 bundle, which is case law bundle 10000352, in which you will find, Advocate Batohi, the date on which the Gauteng J judgment was delivered.
Yes, I see. It's the 26th of February, 2014.
What is the page number, sorry?
000352,
It's in bundle.
CL,
CL2. For us, it's
CL1.
For us, it's CL2. That's there.
My apologies, I'm told it's not one, it's CL2.
Yes, thank you. Proceed.
You would want to deal with the Gauteng J judgment? You want to comment there on?
No, not at the moment. Save for what is contained in paragraph 151 of my affidavit.
It will also be helpful to direct the witness because the judgment, where do you start? Where do you end? What do you have in mind, counsel?
Madam Chair, during before
I think it is permissible to lead her
yes,
on those aspects.
yes, I agree with that. I take it, but I've been informed that she's asking for some time to deal with certain aspects, and that she requests a few minutes. I'm not sure how long, maybe half an hour or so.
If I may clarify, Chairperson.
Before you clarify, Advocate Batoy, is that in relation to this judgment?
Yeah, in relation to, I believe, the judgment and other aspects that she needs to clarify. I was asked to extend this request to the panel.
So that you can also speak to her to enable you to know precisely what it is that she wants to clarify.
Indeed, Madam Chair.
Is that the aspect that you related to us in the morning that pertains to that?
Yes, it pertains to that.
And in respect of which we said we will afford you additional time when we adjourn for tea.
Indeed, Madam Chair.
It is 10:15. We have an hour to proceed to tea. Might I suggest that you plug this aspect and probably proceed to another aspect if there is any? and revisit this very aspect that you wanted to address in relation to 151?
I will not be able, Madam Chair, with respect, proceed with another aspect because the other aspect is the one that she wants to get clarity on and which she wants to consult with. And I would propose that perhaps we should take an early tea recess.
Let me understand you clearly. Are you suggesting that any other matter that might follow is closely linked to 151 to the extent that you cannot proceed outside 151?
And whatever, and indeed, Madam Chair, because I'm constrained at the moment, she wants to clarify certain issues. I need to know what issues they are. She wants to refer back to Dr. Broughton's bundle and in dealing with those issues.
Yes, I understand that.
Yes.
I just want to make sure that, adjourning is not there for the taking. We need to understand that we cannot proceed with any other matter if we decide to park this aspect for a later discussion.
That is so, Madam Chair.
Yes, thank you. In that event, we will take an adjournment. How much time would we need to clarify those aspects with the witness?
May I find her from the witness? How long would you like to have?
Chairperson, perhaps let me clarify that between paragraph 151 and then when we move on to paragraph 152, 152 deals with when Advocate Abrams was appointed. Because of the fact that we dealt with this at very short notice, there's a gap between the Govan judgment and paragraph 152. So we need to look at the evidence there so that it flows and then come to what happened after Advocate Abrams' appointment. I'm thinking, to answer your question specifically in terms of time, I'm hoping that we could do it within an hour at least.
Yes, thank you. Yes, thank you, Council. We will adjourn for tea, which will means that we will adjourn an hour later. Hopefully, you would have finished with this consultation, Council. If not, please send a message through my researcher to alert us that you are not done.
I will, Madam Chair.
We will take an adjournment for an hour. Good afternoon, Council.
Good afternoon, Madam Chair.
May I proceed? Council, remember you are still under oath?
Yes, thank you, Chair.
Madam Chair, we thank the panel for affording us the opportunity to engage further on the issues that we'll be presenting to you. And Advocate Batohi is grateful for the opportunity and says thank you too. We will begin by referring the panel to the supplementary opinion of Dr. Broughton, which is contained in LO1.
Will you please indicate, Council, whether we should disregard where we left? We left at paragraph 151. Should we disregard that?
Yes, if necessary, we will revert to it, but for the moment, disregard it. Then, may I point out that the whole of Dr. Broughton's supplementary opinion contained in LO1
LO1. Page.
It starts from 205 and ends
Is that 0024?
00 LO to 00205.
If I may help, it starts at 171, Council.
Yeah, I'm sorry. 205 is what we're dealing with here. Which page, Advocate Pato?
00171, Council. Starts on that page.
My apologies. 205 was the one that we will be dealing with. It starts at LO 00171. And together with its annexures, it ends on page LO 296.
I beg your pardon?
It ends at
00.
.1038. In other words, it includes all the annexures, all its annexures from page 17 LO 00171 up to LO 01038. It will later be
Up to LO4.
yes, up to LO4.
Ten 038.
01038.
010. That's from all the LOs up to the last one. Just a few pages.
Yes, thank you.
Advocate Patohi, go to Dr. Broughton's supplementary opinion, LO1, bundle on page LO 00205. Are you at 00? Are you at 205?
I am.
Go to paragraph 102 and read 102 into the record.
Thank you. For the purpose of context, Chairperson, if I can just indicate, as you earlier mentioned, in paragraph 151 of my affidavit, we ended with the judgment of Govan J. On the 26th of February 2014. So we're now at 102, paragraph 102, where counsel has referred me, LO 00205. It's subsequent to that, in a memorandum of 5th of March 2014, the Boyson prosecution team did not recommend the lodging of an appeal against Govan J's judgment in light of a concession that counsel had made during that review application. That memorandum, counsel, is an annexure.
Do you want to go to it first, or do you want to read?
I read the whole, should I read
whole-
the entire 102? Okay, I will do that. It would seem that I didn't read it verbatim. Let me do that. While in the memorandum of 5 March 2014, which is Annex to T, the Boyson prosecution team did not recommend the lodging of an appeal against Govan J's judgment in light of the concession made in the matter that there were no statements in the dockets which implicated Boyson in any of the offences with which he had been charged. It would seem that the memorandum which Advocate Chauke forwarded to Advocate Noko, as well as Dr. Ramaite and Advocate Jiba, as per his email of 7 March 2014, must have been the memorandum of 5 March 2014, Annex to T. I'm not sure that we want to go further in that paragraph.
Leave it at that, and let's go to LO4.
For completeness, why don't we have that entire paragraph so that we can understand the entire context? Shouldn't we read the entire paragraph?
Maybe you should. Maybe
Certainly.
we should, certainly.
Chairperson, the entire document will be handed in as an exhibit at some point. I continue. I say this because the email was dated 2 days after the date of the memorandum, Annexure T, and the purpose of this memorandum, entitled Judgment Boyson versus the National Director of Public Prosecutions, was reflected as updating the NDPP and the head of the NPS on the matter following the judgment of Govan J. The purpose of the memorandum, which is Annex to T, to Advocate Broughton's opinion, was also reflected as informing the NDPP on the prosecution team's intended course of action in light of Govan J's judgment. The memorandum was also prepared on the same day of the EXCO meeting referred to above, where it was resolved that Advocate Chauke would report to Mr. Ngasana on the developments in the Boyson case.
Now, go to LO4, bundle, page LO 00882, where you will find a memorandum LO 0082, Madam Chair. Eight,
882.
882.
LO1 00882.
LO4.
LO4.
Yes, Madam Chair. Are you there, Advocate Patohi?
I am.
You'll see there in that.
Perhaps we should wait for.
Yes, thank you.
Thank you, Madam Chair. On that page appears a memorandum which was addressed to Advocate Chauke from the National Prosecution Team and is dated the 5th March 2014. You confirm that?
That is correct.
Council, if I may, you referred us earlier to 102 of 1 LO0 001038 and then 00205. Is there a link between that and this next part that you're referring us to?
There must have been a misunderstanding about 1038. 1038 is where
Yes,
Dr.
yes, it is the part of that opinion.
Yes,
that
where
is
it ends.
Where it ends.
Yes.
And then you referred us specifically to LO1 00205.
Indeed, Madam Chair.
And you are now, after reading that paragraph 102, referring us to LO4 00882.
Indeed.
Is there a link between these two?
There's a link because in paragraph 102.
No, you don't need to explain.
Yes, there's a link concerning the memorandum.
We are at LO4 00882.
Maybe before we proceed, I need to mention that the evidence that is being led currently seeks to address paragraphs 3, 3.1, I just want to have my terms of reference. It seeks to address paragraphs 3, 3.1, 3.1.1, 3.1.3, and 3.1.1.4 of the terms of reference.
Just give me a second. Thank you.
Thank you, Madam Chair. There is subparagraph A in that memorandum which deals with purpose. Can you read that into the record?
Thank you. And Chairperson, just to connect it, 102 at LO 00205 refers to this particular memorandum. It says in the memorandum of 5 March 2014. So this is the memorandum that's being referred to in paragraph 102 LO 00205.
Thank you very much.
If I may pursue.
Thank you,
Thank you,
very much.
Chairperson. Chairperson, the purpose is set out. Paragraph 1, the purpose of this memorandum is to update the National Director of Public Prosecutions, NDPP, and the head of NPS. Chairperson, if I may pause to explain at this point, just so that the panel understands. The head of the NPS, as I explained earlier in the structure, would be the head of the business unit NPS, and DPPs like Advocate Chauke would report. The immediate report would be the head of the NPS and then the National Director of Public Prosecution. So they report to the NDPP through the head of the NPS, just for clarity, Chairperson. So the purpose of this memorandum is to update the National Director of Public Prosecutions and the head of NPS following the judgment delivered by Govan J. of the KwaZulu-Natal High Court on 26 February 2014. The judgment is attached hereto as Annexure A and the indictment as Annexure B. And paragraph 2 says the prosecution team also seeks to inform the NDPP of our intended course of action in the light of this judgment. Chairperson, I don't intend to read the entire memo unless I'm required to, but it sets out in page 000883. It summarizes the judgment. It summarizes the prosecution team's view of the judgment, which I'm happy to read, but I do want to focus.
You don't have to, sorry to interpose.
Thank you.
You don't have to.
Thank you, Counsel.
Flip over to the next page, 883, LO00884 rather.
And Counsel, in that page, on that page, and the purpose, paragraph 2, and of course the heading, the prosecution team also seeks to inform the NDPP, and the memo is directed to the DPP, Advocate Chauke. Should we make anything of that?
You should, Madam Chair.
I think you must let the witness answer.
Oh, I thought
I
it was directed to me. My apologies. My
speak
apologies.
to the witness through you.
My apologies.
Would you please just clear my mind, Counsel? Advocate Watoi, the memo of the one that you've just referred to is directed to Advocate K.M. Chauke, the Director of Public Prosecutions, South Gauteng, from the Katomena Prosecution Team, Director of Public Prosecutions, South Gauteng, Johannesburg. In paragraph 2 of this memo under purpose, it reads, the prosecution team also seeks to inform the NDPP of our intended course of action in the light of this judgment. Now, my question is, should we make anything of the fact that the memo, although it seeks to be directed to the NDPP, in the heading, it is directed to Advocate Chauke, who is the DPP South Gauteng?
Chairperson, reading this memo, it would appear that what is happening here is that the team is briefing, is letting Advocate Chauke, informing him, I should say, about the intention to, it's sort of preparation for reporting to the head of NPS and the national director. So this is the first step in that process. This is the way I see it, as them informing their immediate report, who's the DPP of South Gauteng, about the intention to brief the national director and the head of the NPS, and therefore they summarize this. That is my understanding, Chairperson.
Yes, I asked this in the context that we have been informed that Advocate Chauke was a liaison or rather a coordinator. And the case that you have presented to us is that he was part of the prosecution team. That seems to beg the question, if that is the case, why shouldn't this memo be directed to the NDPP as paragraph 2 suggests?
Chairperson, just to say that my understanding is that shortly after the judgment, the team is summarizing their view of the judgment and what they think the next step should. This is my assumption. I'm being asked to make an assumption because I had nothing to do with this, but on the basis of the way I understand process, I assume that's what the chair would like me to surmise on.
No, I don't want you to, if you are not sure of what is contained in this memorandum, because this is not your writing, and somebody else might be able to explain to us, given the background that has been placed before us.
That is correct,
regarding
Chairperson.
The role of that Advocate Chauke played, whether as a decision maker or as a coordinator. And this paragraph 2 is causing that difficulty to me, because if you seek to direct something to the NDPP, but you do so through or via the DPP of South Gauteng, it may well support the proposition that Advocate Chauke was a coordinator.
Chairperson, if I may, it would also support the proposition, which we say is that he was the de facto DPP in charge of this matter.
Yes, I'll leave it there.
Thank you, Chairperson. If I may proceed.
Advocate Mutsamunyane, I suppose this aspect will be flagged, and maybe the people who prepared this, or the head of the prosecution team, Advocate Maema, will clarify this aspect further.
Hopefully.
Hopefully, because Advocate Batoi is answering the question not directly, he's just trying to assist us. He was not necessarily part of the team that prepared this memo.
Chairperson, if I may clarify, I'm trying to assist the panel with regard to most of my evidence because it relates to evidence in documents and presenting it in a way that the panel would perhaps be able to sift through it. So to clarify that is what I'm attempting to do, is to sift out important aspects of the evidence and present it to the panel.
Yes, but I do also appreciate the fact that you are speaking to the document that you did not prepare.
Thank you,
It
Chairperson.
may well be that the scribe will come here and say something contradicting what you are saying.
Understood,
That's why
Chairperson.
I earlier said, if you are not in a position to answer the question that I'm asking, do say so.
Certainly, Chairperson.
You may proceed, Council.
Thank you, Madam Chair. Go to page LO00884 of the same bundle and look at paragraph 11, which you can read into the record
It's paragraph 11 of the same
of
memorandum.
the same memorandum.
In terms of process, since we do not intend to appeal the judgment, we are of the view that we should call upon the applicant, in this case it would be Boyson, to appear before the High Court to formally withdraw the charges. In the meantime, pending an intended application to you, sir, for a new authorization. And given that this is addressed to Advocate Chauke, I would assume that that reference is to him as sir in paragraph 11. If I may read paragraph 12.
Before you do so, the terms of reference and it may well be helpful, Advocate Mutlamunyani, to, as you indicated earlier, about the relevance of this evidence to the terms. Perhaps we can just capture that paragraph that is relevant to this evidence regarding the appeal. I think it is paragraph 3.1.1.4.
Yes, it is, Madam Chair.
You may cause it to be read into the record, or I may just do so. This subparagraph relates to the allegation in the terms of reference that suggests that the Advocate Chauke instituted an appeal against the judgment of Judge Govan in the review case of Boysons versus Acting National Director of Public Prosecution, 2014-2, SACR 55 KZN, without the approval of the National Director of Public Prosecution, Mr. Mxolisi Nkasana. Notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused, and thus no justification for lodging an appeal against the judgment. Am I correct?
You are, Madam Chair, and maybe to assist the panel further, Mr. Mxolisi Nkasana's appointment was effective from the 1st of October 2013 and he vacated office on the 14th May 2015, which suggests that during this period when this memorandum was prepared, it was Mr. Nkasana who was in office. As at the 5th of March 2014.
That may well be the case, but the point that I'm making is more directed to the portion that Advocate Batoi has just read to us in paragraph 11, insofar as it impacts on the terms of reference that I've just mentioned. And I want to know whether I am correct in understanding paragraph 11 in that way, its relevance to the terms of reference.
Is it directed to me or to Advocate Batohi through me? Chair, Madam Chair, maybe.
I don't know whether you understand it that way as well, Counsel, but I'm speaking to the witness through you.
Advocate Batohi, can you respond?
Okay, so I need to get the dates in my head correct.
Maybe if I can make it through you, Counsel, if I can make it easier. If you look at paragraph 11, LO 00884, the one that you read into the record.
That's correct, Chairperson.
Simply put, to what extent is this paragraph or the contents of paragraph 11 relevant to the terms of reference?
Chairperson, it would be relevant because in this case, it is a decision not to appeal a matter, which is also a prosecutorial decision. And I think it would go further than that because it also refers to an application for a new authorization, which I think would speak to some of the other paragraphs of the terms of reference, which is also a prosecutorial decision.
Batoy?
I
Thank you.
proceed. Thank you, Chairperson.
I have a follow-up question. At paragraph 11, the last line, where you say, in the meantime, pending an intended application to you, sir, for a new authorization, would this, sir, mean Advocate Chauke or the new NDPP?
Chairperson, if we look at the fact that, through you, Chairperson, that the memo is addressed to Advocate Chauke, it appears that this refers to him speaking about an intended, because the application would go through him to the National Director for authorization.
But then it says an application to you, sir,
Yes.
for a new authorization, and we now know that the application for authorization goes to the NDPP, not to the DPP.
That is correct, Chairperson, but it goes through the DPP. If you'll recall, the one document that Advocate Chauke signed on behalf of Advocate Noko, it was referring the application for racketeering to the National Director. So the way I see this is that precisely that the application would go to Advocate Chauke to be submitted to the National Director for a new authorization. If I may proceed, Counsel.
Yes, capital C before
It's
you.
headed Reapplication for Authorization Certificate, paragraph 12. The prosecution team intends to apply to the NDPP for the reissuing of certificates. We shall prepare a new memorandum which outlines in detail the evidence against the applicant. Paragraph 13, we are still firmly of a strong view that there are sufficient facts which justify the reissuing of racketeering authorizations.
Let me take you back then to Dr. Broughton's supplementary opinion, rather, in LO1 bundle, page LO 00205. LO1, Madam Ramachaka, page LO 00205. Now, have a look at paragraph 102, which you may read into the record.
Was this paragraph not read into the record earlier?
It was, Chairperson.
This paragraph was read in earlier, Council.
Yeah, indeed. I'm reminded now. Thanks.
You
Thanks
remember
for that.
I even asked Advocate Batoy for completeness to read all the contents into the record.
Yes, my apologies. I remember now. 104, actually. Should be 104 on page 206. Can you read it into the record?
104 on page 206. As such, it is submitted that Advocate Chauke exercised its decision-making power on a prosecutorial matter. It is evident from paragraph 11 of the memorandum, which we just looked at, that the new application for racketeering authorizations would be submitted through Advocate Chauke, where reference was made to an intended application for you, sir, for a new authorization. In this respect, Advocate Mozing has something to say about it. Counsel, I'll be guided by you.
Go to LO3,
Advocate Parry?
LO3, Madam Chair. Bundle LO3.
Through you, Chair. Council, wouldn't it make more sense to read 104, paragraph 104 in its entirety into the record? Because you see, if we are going to end the reading at wrote as follows, then one would be interested in what is it that is written? What is it that would follow? Just for completeness and a better understanding.
Yes, I
Thank
agree,
you.
Madam Ramahaha, for completeness sake. Advocate.
It might also prevail over you, Council. It might also create an impression that we are selective in presenting evidence to this panel. And we should not be understood to be doing that as evidence leaders. I caution that whatever you do, let us not be seen to be selective, because your role is to present all evidence to us.
Proceed, Advocate
Thank you, Chairperson.
Atohe.
Chairperson, to deal with the last aspect, my understanding was that we were actually intending to read Advocate Mosing's and not leave it hanging. But my understanding is that Council was in fact referring us to Advocate Mosing's affidavit so that we actually read exactly what follows, but from his affidavit and not from Dr. Broughton's opinion. So that would explain it. We were actually going there to read it, but not through the opinion from the affidavit itself. So Council, should I read it from LO00?
Advocate Batoi, we are referred to a page and a paragraph. And what you read is left hanging. Now we are jumping from that paragraph to another document, when the contents of that very document is right in front of you.
That is correct.
So we
we'll
are made to jump from one document to another. And as my sister, the Makhaha, has thus pointed out, that sentence is hanging. It says, who wrote as follows. And that paragraph is there. Why don't you read it from the same document? If need be, then after 104, you can then say, this extract comes from Advocate Musin's affidavit, which is at whatever document.
Moreover, that sentence says it's an extract from Advocate Musin's affidavit. So it's clear that what is being quoted here, it's from the affidavit of Musin. Thank you.
Thank you, Chairperson. That does make it easier. I'll proceed. I continue. In these respects, Advocate Mosing, in his affidavit, wrote as follows. After judgment was delivered on 26 February 2014, we all acquired a copy thereof and perused it. I requested a meeting with the prosecuting team and Advocate Chauke to discuss the judgment, and it was agreed to meet on 3 March 2014 at the DPP offices in Johannesburg. During the meeting, we discussed the judgment in detail, and we came to the conclusion that the court arrived at the judgment mainly on the basis of the concession attributed to our counsel, and that there was no evidence that implicated Boyson with the predicate offences, coupled with the problems regarding the annexures to Jiba's answering affidavit and the corresponding silence to address the shortcomings thereof. Advocate Chauke, who was present during the hearing in court, explained to us what transpired when this concession was made and indicated that it was during counsel's address to court. It was apparent to us that there may have been some misunderstanding between counsel and the court. The entire team felt that it was in any event an incorrect concession, if it was indeed made consciously, and we could not understand how counsel could have made it in the light of all the evidence presented to him by the prosecution team. Advocate Mosing goes on to say, we concluded by agreeing as a team that though not satisfied with the outcome of the matter, at least the door was still open to bring a new application for racketeering, a new racketeering application as indicated in the judgment, and it would therefore not be necessary to appeal the judgment. The team would accordingly prepare a memorandum for the NDPP accordingly. At 105, Advocate Chauke clearly therefore endorsed the lodging of a new application for racketeering to be issued against Boyson. This action on the part of Advocate Chauke was then more than simply putting together and coordinating a prosecuting team to conduct a prosecution in another DPP's decision. In fact, what happened in this meeting was that a prosecutorial decision was taken to apply for fresh racketeering certificates. That is, that the last part is is my comment, Chairperson, and not in the document.
Which last part?
The part that I mentioned, Chairperson, what happened during this meeting was that there was a prosecutorial decision taken, including by Advocate Chauke, to make a fresh application for racketeering authorizations, or to bring a new application for a racketeering authorization.
Is that not reflected in 105?
Yes, that's correct, Chairperson.
So it is not you saying that, it's the author of the memo.
I agree with that proposition, Chairperson.
Proceed, Council.
Just one thing, my
Beg
sister.
your pardon?
Is that your understanding that this extract that you have read into the record is an extract of an affidavit deposed to by Advocate Mosing in his capacity as the leader of the prosecution team?
Chairperson, it is an extract of Advocate Mosing's affidavit. That's the quoted part. He was not Advocate Maema was the leader of the prosecution team, not Advocate Mosing. This is by Advocate Mosing.
Right. Yes, thank you. But nevertheless, was okay. Let me put it otherwise. In what capacity would you say Advocate Mosing wrote this affidavit, this extract in particular?
Chairperson, we dealt with this at some point. He was at that point, I think it was the head of the special projects team at the VGM head office, and dealt with the coordination of racketeering applications.
So it is in that capacity that you believe he wrote this affidavit, this extract in particular. Our focal point, until I indicate otherwise, is this extract in particular.
Yes, it would have been in that capacity that he wrote
It was
that
in
extract.
capacity. And is it correct that Advocate Chauke was not part of the prosecution team?
He was not. I was trying to explain it yesterday that the Advocate Chauke was the DPP, and there's a team of prosecutors that would actually go into court and prosecute the matter. And that team was led by Advocate Maema, and Advocate Chauke was the DPP in charge of this team at a higher level.
Yeah, the question that I'm asking is about him being part of the prosecution team.
Well, he would not have been part of the team that would have been prosecuting it in court.
Yes, thank
That's
you.
correct. Thank you, Chair.
I do have a follow-up, my sister, if you can switch off. What do you understand, or what is your understanding of the last 5 sentences of that quoted paragraph that starts with we, maybe I should read it for you. We concluded by agreeing as a team that though not satisfied with the outcome of the matter, at least the door was still open to bring a new racketeering application as indicated in the judgment, and it would therefore not be necessary to appeal the judgment. The team would prepare a memorandum for the NDPP, informing him accordingly. And I'm asking your view, given your comments after you read paragraph 105.
It appears from that extract that has been read out now that the team had decided to apply for new racketeering applications and that a memorandum was going to be prepared to be submitted to the national director.
Would then that decision be attributed to Advocate Chauke or to the team?
To all of them, because Advocate Chauke was the DPP in charge and they were all in this meeting. Well, I don't know exactly whom, but it appears it was a meeting with the team. The names are not set out, but Advocate Chauke was part of this meeting.
Thank you.
I beg your pardon. To that end, given paragraph 105, which is actually the opinion of Dr. Broughton, saying Advocate Chauke was more than simply putting together and coordinating a team. He acted as part of the prosecutorial decision-making. This is basically what he is saying there. Do you repeat that in your affidavit, if you recall?
I'm not sure if I repeat it, but I agree with that.
You endorse that?
I do.
And this aspect, or rather this evidence, seeks to support the allegations in the terms of reference at paragraph 3.1.1.1. Am I correct?
Yes, that is correct, Chairperson.
Thank you. You may proceed, Council.
Thank you, Madam Chair. Maybe to put the affidavit of Advocate Musing into context in order to assist in answering the question that was posed to you by Madam Ramachakha. I should refer you to bundle LO3, page LO 00704, which contains Advocate Anthony Musing's affidavit. That's where it starts.
That is correct.
The circumstances under which this affidavit was made was that it was made with a view to a criminal case. It appears here as Silverton Cass, although it's not clear as to the number there, but we were informed during the break that it is 622 of 10/2014. Is that correct?
That appears to be the case, although it's not
Yeah.
photocopied very well.
What criminal case, if you know, was he deposing to this affidavit for?
I think it was the perjury case against Advocate Jiba, if I'm not mistaken.
It is marked A12. We know that the A's are in the docket.
That is correct.
These are witness statements in dockets. Can you confirm that?
That is correct. The witness statements are marked with an A, and they referred to as being in the A clip of a docket, which has the witness statements.
Now, this statement stretches up to page LO00737. Am I correct?
Yes, that's correct. This affidavit.
LO00737, Madam Ramagaga, that's where it ends. Let me take you back to,
If I may, correction, I'm not sure. My bundle seems to have a signature at 00720. I'm not sure if it's a duplication or whether it's another affidavit. There's another affidavit that starts at 00721. So it might be the same or it might be different affidavits. I'm not sure if it's a duplication, Counsel.
it appears to be a duplication.
I beg your pardon?
It appears to be a duplication, Madam Chair. A duplication of the statement of the affidavit of Advocate Anthony Musing.
Would you please ask your team to help you to ascertain whether we are dealing with repeated documents here?
Thank you, Madam Chair, for the indulgence. I'm informed that it is a duplication of the same statement of Anthony Musing, Advocate Anthony Musing, that starts on page
Shouldn't we then discard the second affidavit that starts at LO00721 and focus on the one that starts at LO00704?
that would be prudent to do so.
We will strike through the second affidavit.
And I may mention that it appears at the end of both statements that they were deposed to before one Major General Taiwe. Both of them have the same names, name of the Commission of Oaths.
I suppose that is the reason why you say they are a repetition. The second one is a repeat of the first.
Yes, Madam Chair. Now, I'm taking you back to Dr. Broughton's document, and we are on page LO00206. Go to page 106, rather paragraph 106. LO1. LO1. LO 00206.
Sorry, Council, you just referred us to LO3, LO 00704, the one that is repeated in the next batch. So are you moving from that one, this affidavit, or you just throwing it to our attention as referred to in paragraph 104?
I will revert to it, Madam Chair. I just wanted her to read into the record paragraph 106 in
Please
its
speak up,
totality.
Council. Please speak up.
I wanted the witness to read into the record paragraph 106 in LO1, LO 00206 in its totality. Advocate, let's off.
Yes, thank you. So we're going back to LO2, LO 00206, paragraph 106.
Indeed.
Paragraph 106.
Paragraph 106.
Thank you. It's LO1, not 2. Thank you, my sister. You may proceed.
Proceed and read it into the record, Advocate Patohi. Paragraph 106.
Nonetheless, Advocate Mosing proceeded in his affidavit to indicate as follows. A few days after the meeting, I received an email from Chauke informing that a consultation with counsel had been secured to hear from counsel firsthand what his opinion on the judgment was and to get some explanation for the unfavorable outcome. I naturally attended this meeting on 13 March 2014, and so did the entire prosecuting team, including Advocate Chauke. Counsel raised a number of issues with us that he felt the court had erred, including interpretation of case law. He took us through the entire judgment, pointing out instances where he disagreed with the judgment. Also, that court erred in setting aside the decision to prosecute on counts 8 to 12, as that was not taken by the acting NDPP, but the DPP. Counsel also indicated that he did not believe that he made a concession regarding the lack of evidence implicating Boyson, as stated at paragraph 29 of the Govan judgment. The result was that we were satisfied as a team that there were merits to appeal as advised by counsel. It was agreed that counsel should therefore, in the meantime, prepare the application for leave to appeal, while Chauke would brief the NDPP, Mr. Ngasana, who in the meantime had been appointed the NDPP, about the need to appeal the judgment and to obtain his consent. After the meeting with counsel, Chauke again reiterated to us that he will call Dr. Ramaite, the head of NPS, and his direct supervisor, and also brief the NDPP accordingly. I was not made aware of further developments thereafter concerning the appeal process. Here again, I continue on 107. Advocate Chauke exercised a decision-making power on a prosecutorial matter, namely relating to the decision to appeal the Govan J judgment and accordingly approach the NDPP on the matter. Also, the observation by counsel that it was the DPP who took the decision to prosecute on counts 8 to 12, those would be the predicate offenses, against Boyson is of significance. It is submitted that counsel must have been referring to Advocate Chauke, as it was not Advocate Noko who signed the recommendation. And prior to the signing of this recommendation, she had not studied the case dockets as indicated above. She did not know anything regarding the merits of the Boyson (Cato Manor) case as per the case dockets. So here again, the decision to appeal is a prosecutorial decision that is being taken by Advocate Chauke and the rest of the team with him.
Advocate Batohi, let me take you back to LO3, which contains the affidavit of Advocate Musing. You remember
Page number?
the page number is
I think I have it, it's at 704. Is that the one?
it starts there. It starts there. But I refer you to paragraph 16. I'm reminded that you read paragraph 16.
Yes, that was what I read from Dr. Broughton's opinion. It
So
was
it's
a
an-
quotation of this part.
It's an extract from this.
It's an extract, correct.
Now, go to 17. Paragraph 17. Please.
Which paragraph? 17
Paragraph 17.
of Advocate Musing's affidavit.
Yes, which appears on page LO00714 of LO3, bundle LO3.
Proceed, counsel.
Proceed to read paragraph 17 into the record.
I did read, I stand to be corrected, paragraph 17 until, if we turn over the page, until about halfway down that page, I was not made aware of further developments concerning the appeal process. I can continue from there if it's...
You may continue from where you left off.
On 7 March 2014, Advocate Chauke apparently forwarded to Noko a copy of the memorandum that he was going to present to the NDPP and Ramaite regarding the appeal. I was not copied on this mail and have not seen this memorandum, but merely received an email in this regard from Maema on 11 March 2014, and that's attached as an annexure to his affidavit. In the meantime, the prosecution team and the investigation team met on 14 March 2014 in order to further discuss the implications of the judgment on the entire case. I also attended this meeting, but Chauke was not part thereof.
Go to confer with my colleagues, Madam Chair. I want to refer you, thanks, Madam Chair. I managed to locate it. I want to refer you to the same bundle that we're at, LO3, page LO 00765, wherein you will find an email there, email LO
LO 00
765.
765.
Are you there?
I am.
Can you read the email into the record?
This is an email from Advocate Chauke, dated 26 March 2014 at 1:13 p.m. to it's Estelle and then an NE Governor, and also Moipone Noko, who would have been the DPP acting or appointed, I'm not sure, as well as to Council Hodes and others, including Mr. Ngasana and members of the team, prosecution team. It states, "Good day, State Attorney Governor." So it's an email to the State Attorney. On Tuesday, 25 March 2014, the NDPP has decided not to appeal the judgment in the Boyson matter. Accordingly, the notice of application for leave to appeal must be withdrawn. So this indicates that the National Director, Mr. Ngasana, at this point, had decided not to appeal
Which,
that matter.
which then takes us to paragraph 109 of bundle LO LO1 on page 207, LO 00207.
LO 00
207.
207.
Indeed, Madam Chair. Paragraph 109, are you there?
I am, Counsel.
And you read it into the record.
Advocate Mosing, in his affidavit, notes that on
Please, wait a minute.
It's LO1 bundle. The page is LO 00207.
This is Dr. Broughton.
Dr. Broughton's opinion, supplementary opinion.
Not just refer us to numbers. Go back to, just to go back to Dr. Broughton's memos to help us to quickly find our documents.
Dr. Broughton's opinion, are you there?
I am, Counsel.
Be kind enough to read paragraph 109 into the record. Read it in its entirety.
Sure. If I may proceed, Chairperson.
Yeah.
Advocate Mosing, in his affidavit, notes that on the following day, 25 March 2014, he was again called to Mr. Ngasana's office before a meeting was to take place later that day between Mr. Ngasana, Advocate Chauke, and the Boyson prosecution team, at which meeting Mr. Ngasana would inform Advocate Chauke and the prosecution team that the appeal in the Boyson review matter was to be withdrawn. Mr. Ngasana stressed that he did not receive any memorandum on the Boyson matter and was not briefed and only received a media query about the appeal. When Advocate Chauke and the prosecution team arrived, the meeting between them, Mr. Ngasana Advocate Mosing and Dr. Ramita proceeded. At the meeting, Ms. Ngasana referred to an email he sent to Advocate Chauke requesting a written brief or explanation as to why the Boyson matter was being dealt with by the DPP South Gauteng, Advocate Chauke, whereas the matter arose in KZN. This, with respect, is the first time we have it on evidence and information gathered that the top leadership of the NPA questioned how it was that the Boyson case was being handled by Advocate Chauke, whereas Advocate Noko was the DPP of KZN. Advocate Mosing states that Advocate Chauke explained that he attended a meeting in 2012 and the then acting NDPP Jiba and the former acting DPP of KZN, Advocate Molochwa, and that he was requested to assist with a team to prosecute the matter. However, on evidence and information gathered as dealt with in this supplementary legal opinion, Advocate Chauke grossly misrepresented to Mr. Ngasana what his role was with the Boyson case.
Go to LO 4.
Sorry, help me understand here so that we don't, I'm not confused. At the beginning, it's a quotation from Advocate Musing. Up until the last footnote, 90. And I take it that from, however, on the evidence that is Dr. Broughton's opinion.
That is correct.
Thank you.
Actually, I didn't realize the quotation ends at footnote 90.
Perhaps, Counsel, if I may, just to guide ourselves as to where we come from. All these extracts or portions that you are referring to seeks to address the purpose of the memo as captured in paragraph 11 of Dr. Broughton's memorandum.
Opinion.
Dr.
Broughton's opinion. Is that what Madam Chair is referring to?
Yes. That seeks to address the aspect dealing with the decision, or rather the alleged decision to prosecute the appeal by Advocate Chauke. Correct?
That is correct.
And you are referring us to all these paragraphs or portions that supports that allegation in the terms of reference, supposedly paragraphs 3.1.1.1 regarding the decision to prosecute, and 3.1.1.4 regarding the institution of the appeal by Advocate Chauke.
That is correct, Madam Chair.
I want to make sure that we don't lose the thread as to where we are and why we are there. You were drawing our attention to something else in the memo after 109. Dr. Broughton's document, opinion. 109, which has just been read into the record. I'm I'm sorry to interrupt you. We were at paragraph 109, or had just finished reading that paragraph into the record.
Indeed, Madam Chair.
Proceed, sir.
Advocate Patohi, go to paragraph 111, on the same page, LO1, LO 00208. Triple one.
111.
Proceed to read the paragraph 111, into the record.
Advocate Mosing,
I beg your pardon, Counsel. I beg your pardon. Are you jumping 110 deliberately?
Deliberately so. In fact, it has been dealt with in a sense, because what is being set out there has been referred to in Advocate Mosing's affidavit. And the concerns that Mr. Nkasana is said to have raised have been dealt with in the previous paragraph.
You may proceed, Counsel.
Proceed,
thank you.
Advocate.
Paragraph 111 reads, Advocate Mosing then points out in his affidavit that on the following day, 26 March 2014, it was Advocate Chauke who wrote an email to the State Attorney conveying the decision of the NDPP to withdraw the appeal in the Boyson review matter. And that's the email that we had just referred to. Advocate Mosing, the memo opinion continues. This email communication was attached to Advocate Mosing's affidavit as Annexure M and is appended to Annexure F here too. It is striking that Advocate Chauke notified the State Attorney of the withdrawal of the appeal, thereby underscoring that he played a leadership role with regard to the review case, as with the Boyson prosecution. And this after the trailing email of 26 May 2014 shows that Advocate Hodes submitted a copy of the leave to appeal to Advocate Chauke on 17 March 2014, notifying that it would be served on 18 March 2014.
Counsel, if I may, the reason why I asked you about paragraph 110 was to tie it to the paragraph 109, especially the last sentence, which speaks of that meeting referred to in 109. The last sentence then tells us what then happened at the end of that meeting. Am I right?
That is so, Madam Chair.
Because 109 tells us what happened at that meeting. And the last sentence tells us then the way forward as was decided at that meeting. The meeting was then adjourned with the understanding that the team will prepare a detailed briefing for Mr. Nkasana of the entire Boyson's case that will take place on 7 April 2014. Subject to correction, I thought that part is important, or maybe important, as to what then happened regarding this very issue that we were dealing with. If I am wrong, you'll correct me.
Advocate Batohi, do you have any knowledge about what happened? Whether Mr. Nkhasan was briefed subsequent thereto, or
Which appears from paragraph 110 is that there was a meeting on the 25th of March 2014 between Mr. Ngasana, and this is according to Advocate Mosing in his affidavit, between Mr. Ngasana himself meaning, I assume, Advocate Mosing, Dr. Ramaite, Advocate Chauke, and the prosecution team. Mr. Ngasana raised concerns over him not having been briefed as to the question of appealing the Govan judgment. He therefore felt that he was being undermined. Advocate Chauke stated that he had briefed Dr. Ramaite about the appeal, whom he expected in turn would brief the NDPP on the matter. Mr. Ngasana stressed that he was angry on learning about the notice of appeal and that he had taken the decision to withdraw the notice of appeal. Dr. Ramaite confessed that he had received the documents from Advocate Chauke, but he said that it was detailed and he did not look at the documents. This is in quotation marks. It was detailed and he did not look at the documents, though he said he raised his view with the NDPP not to go ahead with the appeal process. That's the end of the quote in that regard. The meeting was then adjourned with the understanding that the team would prepare a detailed briefing for Mr. Ngasana of the entire Boyson case that would take place before 7 April 2014.
I just mentioned this part because you will recall that the very meeting that is mentioned at 110 is the very meeting in relation to 109. So what is stated in 110 is a continuation of what transpired at that very meeting
Yes.
of 109 of
That's
the
correct.
25th of March 2014.
Mm.
That is why I consider that the contents of 109 are may be of relevance. Should I ask counsel, through your advocate, Mhlamanyane, it then follows, if I'm correct, that the contents of that paragraph should also be placed on record.
Chairperson, it is indeed a continuation because it does refer to the 25th of March 2014.
You have read that into the record and you confirm that it is relevant.
Yes, that is correct, Chairperson.
Thank you.
thank you, Madam Chair.
Chair,
I'm made aware.
I have a follow-up on what Chair had raised in relation to paragraph 10. Doesn't paragraph 10 then tell us who took the decision to withdraw the notice of appeal?
Chairperson, is it paragraph 110, I assume? Yes, it's the National Director, Advocate Nasana, who took the decision to withdraw the notice of appeal. That's the withdrawal.
Thank you, Madam Chair. I'm alerted to the fact that it could be lunch break already. It's 1:30.
Yes, thank you, Council. 1:45. Our lunch time will be 2:15. I thought that we have been having lunch at 2:15. Might I suggest that you finish this aspect in relation to the prosecutorial decision to note an appeal in relation to terms of reference 3.1.1.4.
Let me then proceed. Advocate Patohi, go to paragraph 112.
I must also just remind myself and you perhaps that paragraph 111 was earlier read into the record when I interrupted you.
Indeed, it was read into the record.
Thank you, Counsel.
Proceed to read into the record paragraph 112 of Dr. Broughton's supplementary opinion on page LO 00209 in bundle LO1.
Chairperson, for the sake of clarity and so that there isn't confusion, I should say that the way this opinion flows, we've dealt with the decision to prosecute the appeal, then Mr. Ngasana deciding to withdraw the appeal. And now when we go to 112, it takes us back because Dr. Broughton is now referring to some communications that he received. And you'll note that it actually relates to communication between Advocate Chauke and Advocate Holders on 16th and 17th of March. And it's still relating to the application for leave to appeal. So I just want to be clear about that so that we're not confused about the sequence of events. If I may then proceed, Chairperson.
Thank you. It is helpful.
So in paragraph 112, Dr. Broughton states as follows. On the last mentioned aspects, evidence has been provided to me by Advocate McAdam, attached hereto in the evidence bundle as Annexure U, and Annexure U would be, we don't need to go there now, Chairperson, but for reference, it would be at LO 885. I will continue reading from in paragraph 112. He received an evidence bundle, which is comprised of email exchanged between Advocate Chauke and Advocate Holders on 16 and 17 March 2014, relating to finalizing the application for leave to appeal in the Boyson matter. In the email of 17 March 2014 from Advocate Chauke to Advocate Holders, the former stated as follows, appertaining what had to be included in the application for leave to appeal, open quotes, I suggest that counsel should also place more emphasis on the fact that Boyson made a memo of the rewards indicating his direct involvement. Maybe this must also be canvassed during the argument at the application for leave hearing, close quotes. Advocate Chauke hereby made a prosecutorial decision as to how the application for leave to appeal was to be dealt with upon receiving from Advocate Holders on 16 March 2014 and perusing a first draft of the application for leave to appeal. It is to be noted that the NDPP would have had to be cited as the applicant in the application for leave to appeal, but by the submission of the draft of the notice of appeal, Mr. Ngasana had not been briefed thereon and had not approved the filing of the leave to appeal.
Now, go to LO 00885 in bundle LO4, page LO 0085, where you'll find an email from Advocate Chauke dated the 17 March 2014.
That's correct.
Please read it into the record.
It's an email from Advocate Chauke to other persons, including Lawrence Hodes. And the subject line is application, it appears, it's APPLI for leave to appeal, Boyson versus the Acting National Director of Public Prosecutions. It states, good day. I suggest that counsel should also place more emphasis on the fact that Boyson made a memo of the rewards indicating his direct involvement. Maybe this must also be canvassed during the argument at the application for leave hearing.
Council, that email, is it at LO4?
That email, this email is in LO4, Madam Chair,
Page?
page LO 00885.
LO 00
885.
885.
Perhaps for completeness, the email before that is from Estelle, also copying to Advocate Chauke, also copying Lawrence Hodes, application for leave to appeal in the Boyson versus Acting National Director of Public Prosecutions. Herewith, please find first draft to enable you to compile the memorandum. Please excuse formatting as we are experiencing problems on computer. So this speaks to Dr. Broughton's opinion where he refers to the draft of the application for leave to appeal, which would have been sent to Advocate Chauke.
Are you reading the email trailing? And
Yes, the
please,
one-
just let us be clear so I should not get confused. On which page are you?
Yes, on the same page, 885, that we were on, LO 885. It's just below the one that I'd read. So it's
No.
an earlier email.
Now, who's Estelle? The
Well-
one from whom this email emanated?
I have no idea, but I would think she's from Advocate Hode's office, but I don't know for sure. But it appears that from the context that would be the case.
It was addressed to Advocate Chauke,
That's correct.
dated the 16th March 2014.
That's right, at 1:23 p.m.
Right, go to the next one, the next page rather. On this, on 886, LO 00886 in bundle LO4. There's an email there. You see that?
I do.
It has not yet been read into the record, not so.
I will do so. It is an email dated 11th, is it 11th of April or is it 4th of November? I never know what the sequence is here. I think it's 11th of April because the emails below are in full 8th of April, and that seems to be the chain. So on the top, it is 11th of April 2014 at 3:20 p.m. from Mr. Ngasana to Advocate Chauke. Well, that simply says noted. So I think the email chain is going from the bottom to the top. So perhaps I should start from the
Sent
email.
from my iPhone.
Yes, I'm trying to get the sequence correct because in the top email, all that Mr. Ngasana says is noted, sent from my iPhone. So there's below that, there's an email of 11 April, it's the same day, earlier, 2:51 p.m. from Advocate Chauke. It's not clear who it's sent to from this document, but it says, "Good day, Dr. Ramaite," and that would have been his immediate report, line of reporting, the head of the acting head of NPS or head of NPS at the time. I refer you to the comments and reservations of both. I refer you to the comments and reservations of both the NDPP and yourself regarding my involvement in the Cato Manor matter. I also refer to a subsequent meeting that I held with the NDPP on 8 April 2014. I hereby confirm that I will no longer take part in any way regarding the management and prosecution of this matter. I have accordingly informed the team leader, Advocate Maema, and the DPP KZN, Advocate Noko. Again, this email refers to the management and prosecution of this matter. And then the email at the top from Mr. Ngasana, who states noted. The response.
Counsel, if I may, regarding these emails, LO 00885, the subject in the first email is application to appeal. In the subsequent email by the lady, Madam Estelle, the subject is also application for leave to appeal. In the subsequent email at page 1000886, the top one, the subject is the Nkabinde prosecution presentation. Should we make note of that, of the differences in the subjects of these matters, particularly the one at 00886? The one that has been noted by Mr. Ngasana. Is it Mr. Ngasana or the noted? Who is noting that email?
It's from Mr. Ngasana, Chairperson.
It's from Mr. Ngasana.
That's correct.
And it's addressed to Advocate Chauke and a number of people there.
That's correct, Chairperson.
And that email is headed Nkabinde prosecution presentation. Should we understand that to include the earlier subjects, application for leave to appeal in the previous two emails?
Lest I be seen to be answering from the bar, giving evidence from the bar.
You may ask the witness, it's the subjects that I'm being concerned about.
Can you clarify that,
Yes,
Advocate
certainly.
Matohi? Because we will still go to the PowerPoint issue.
Yes, so Chairperson, the first emails on LO885 between Advocate Chauke and Advocate Hodes, and it deals with Advocate Chauke making suggestions to Advocate Hodes about the application for leave to appeal. So that's a separate issue from the subject matter relating to the prosecution presentation, which happens much later.
The
That
next
is
page,
on 886.
Yes.
That's correct.
it's a separate issue.
That is correct, Chairperson.
And my understanding, Counsel, is that you are addressing a specific aspect with all these extracts relating to the power or the decision to prosecute or note the appeal.
That is so, Madam Chair. With
See now at 0L00886, we are now referring to that email that seems to address, as Advocate Matohi has indicated, a separate matter.
that is so, Madam Chair, which will go into.
Is it of relevance? I beg your pardon, sir. Is it of relevance? That is the Nkabinde prosecution presentation subject.
It is of relevance, and we will go over to it in a moment.
Yes, thank you.
Go to paragraph 115 of Dr. Broughton's opinion on page. Dr. Broughton's opinion is LO1, by the way, bundle LO1, page LO 00209. At the bottom of the page, towards the bottom of the page, rather, you'll see paragraph 115, where the PowerPoint presentation is referred to. Can you read it into the record?
Yes, thank you. Chairperson, for context, I'm not going to read paragraph 114, but Dr. Broughton received this PowerPoint presentation from Advocate McAdam, and then he deals with it in paragraph 115. He received it together with other documents. In 115, he deals with the PowerPoint presentation, and it was sent by Advocate Maema to Advocate Chauke and fellow members of the Boyson prosecution team in the email of 8th April 2014. The subject of this email was noted as Cato Manor Prosecution Presentation, 7 April 2014. In this presentation entitled Cato Manor Prosecution Presentation, 7 April 2014, the prosecution team and Advocate Chauke were requesting the reissuing of racketeering authorizations in the Boyson Cato Manor case. On the as the name of word as well as the supervisor in inverted commas of the case. I'm not sure if we want to go into what Advocate McAdam has informed Dr. Broughton about it. Should I continue or stop at that point, Counsel?
Please continue.
Advocate McAdam informs me that misrepresentations were made in this PowerPoint presentation as to the alleged evidence of the facts of the case, and that accordingly attempts were being made to mislead Mr. Ngasana into reauthorizing the racketeering charges in KASU. This aspect would need to be fully explored and ventilated in a section 12.6a inquiry. The aspect has nevertheless been discussed in emails from Advocate McAdam to Advocate Hully as aforesaid, dated 11 August 2022 and 29 December 2022. This email is attached here to in the evidence bundle as Annexure W.
Advocate Batohi, can you explain what a PowerPoint presentation is? For some of us, we don't know what that entails. What does it mean?
It's a presentation that a presenter would prepare to, when briefing or someone or presenting to an audience. It's a presentation that would set out key aspects of your presentation in a PowerPoint form.
Is it used to present specific aspects of one's responsibilities to a senior or to seniors? From juniors to seniors?
It depends what the purpose of the PowerPoint presentation is.
At that particular moment?
In this one, if we perhaps go to the PowerPoint presentation.
Yes, we'll go there. I just wanted you, in general terms, to explain it. But let's go there. Maybe it might be
Yes, I think it might be
advisable
helpful
that you would be able to fully explain it in order that it be clear to everyone else.
It might be, Counsel.
Go to it.
Counsel, before you go there, just for my clarification, who is Advocate McAdam and what role did he play in this whole scheme of things?
If I may explain, Advocate McAdam was a Deputy Director of Public Prosecutions in the National Prosecuting Authority, and he was attached to the Priority Crimes Litigation Unit, and then the Priority Crimes Litigation Unit, a unit that deals with certain priority crimes like terrorism and international crimes, etc. And then he was, if I recall correctly, and I'm speaking from memory, he was the liaison person between the Zondo Commission and the NPA at some point, but I stand to be corrected. But he was involved in to some extent in these matters as well.
Just as a follow-up, during the Cato Manor case, What role did he play?
During the Cato Manor case, that would be around 2012, 2013, 24. At that point, Chairperson, through you, I stand to be corrected, but my understanding is at that time he would have been he would have been playing the same role that I explained a few minutes ago, being a Deputy Director of Public Prosecutions in the PCLU, that's the Priority Crimes Litigation Unit in the NPA.
Let us then go to
Advocate Mutlamunyane, this presentation, which is referred to in that email that I asked you about, is being referred to in these paragraphs that have been read into the record. Are we at any stage going to be given the presentation, the PowerPoint presentation?
in a moment, the panel will be referred to the documents that deal with the PowerPoint presentation. Should I proceed and do so?
No, I'm just asking. I don't know how you want to proceed with your evidence, but I just thought that it seems to me that much is made of this power presentation, and it may be important that we have a look at it.
I was in fact going to it as my next point.
I don't want to derail you
Not at
in
all.
any way, but you can just flag that point so that you come back to it at a later stage if you so wish at this point.
Madam Chair, I'm actually getting to it, right into it, so that the Advocate Patohi should be in a position to fully explain what it entails. It is on the next page, actually, LO4. This page on LO4, LO00886, where the subject matter is the Katomana prosecution presentation, is actually followed by the presentation itself on the next page. Unfortunately, these pages are not numbered, but I would accept they are part on the side. I don't see numbering here. Oh, my apologies. They are numbered. They are numbered. The next page is LO00887, Madam Chair, and your sisters, which contains the Katomana prosecution presentation with a date there appearing as 7 April 2014. My eyes missed this numbering because it's now put on the left hand side, and I was my concentration was on the top right corner.
The last paragraph that you referred us to in LO 00210 was 116. Do you intend to go to that PowerPoint, or you want to first deal with the further paragraphs before you go there?
It was 115, paragraph 115, Madam Chair. I wanted to tie it with the presentation itself before I go to 116.
Yes, thank you. Thank you.
Are you there, Advocate Patohi?
I am, Councillor.
It is LO4 on page LO 00887, wherein you'll see Katomana prosecution presentation. Just explain what exactly was happening here.
Well, if one looks at page one, the page before that, the presentation where the emails are, the email at the bottom from Selo Maema to Advocate Chauke and other members of the team, its subject is emailing, Cato Manor presentation, 7 April 2014. Dear colleagues, I enclosed herewith the slide preparation by the team for your attention. And then it appears that that is the presentation that follows, that was attached to that email, because it is dated on the first page, 7 April 2014. It's Cato Manor prosecution presentation is the heading. On page 887, it lists the names of all the team members, and on the right-hand side, it lists Advocate M.A. Chauke as the DPP South Gauteng, in brackets, supervisor.
Before you leave that topic, what is a supervisor? What do you understand by a supervisor?
Well, ordinarily, it's one who supervises other persons, but the NPA Act does define the supervisory function in terms of one of the powers of the DPP, and I think it's section 22.
It's 24(1)(c), I believe. Let's go to it immediately so that when you explain it, you should be
Section
having it in front of you.
24(1)(c) of the NPA Act.
Yeah, read the whole of 24(1). Maybe that can help. Having a copy in front of you.
I do. I'm waiting for the
Okay.
panel to continue.
4.
Section 24, Madam Chair.
May I proceed, Chairperson?
Proceed, Madam.
Thank you. Section 24, powers, duties, and functions of directors and deputy directors. Subsection 1, subject to the provisions of Section 179 and any other relevant section of the Constitution, this Act, or any other law, a director referred to in Section 13(1)(a) has, in respect of the area for which he or she has been appointed, the power to A, institute and conduct criminal proceedings and to carry out functions incidental thereto, as contemplated in Section 23. B, supervise, direct, and coordinate the work and activities of all deputy directors and prosecutors in the office of which he or she is the head. C, supervise, direct, and coordinate specific investigations. And D, carry out all duties and perform all functions and exercise all powers conferred or imposed on or assigned to him or her under any law which is in accordance with the provisions of this Act. All of these powers are powers of directors in respect of the area for which he or she has been appointed, as per subsection 1.
Will subsection 2 be of relevance?
Advocate Batohi.
I can read that into the record. In addition,
Just a minute, you don't
The
have
question
to.
is whether it is of any relevance.
if I could read it first, Chairperson. Chairperson, it wouldn't be of relevance because it appears to an investigating director and not to a DPP a Section 13(1)A DPP. So it wouldn't be of relevance, Chairperson.
Section 6 DPP would not be an investigator, cannot be an investigating director.
That is correct, Chairperson.
I see in subsection 2B, it refers to the prosecution of an appeal in any court in the Republic, emanating from criminal proceedings instituted by the investigating director or the persons authorized thereto by him or her.
I see that, Chairperson.
You maintain that it is of no relevance for our purpose.
No, because it refers specifically to the investigating
Investigating
director in that section.
Thank you.
If we may take it further, maybe to assist and to put it within context.
I do understand to my question.
I wanted to go to 8 so that it should be read with and be contrasted and compared with
Sub 2.
with sub 2.
I think
because
the
it relates
answer, the answer by
answer.
Advocate Batoyi is
Suffices.
I'm satisfied.
Advocate Patohi, I want to take you to paragraph 118 in LO1, Dr. Broughton's supplementary opinion. But before I do that, maybe for completeness sake, start from 116 and read it into the record, including 117.
It's at page 2 LO00210.
Yes.
Please give me a second. Let me go back to that opinion. Yes, thank you. It's LO00
210, Chairperson.
210.
Oh, which one?
It's a volume.
The fact of the matter is that Advocate Chauke, along with the prosecution team, took a prosecutorial decision in reapplying for racketeering authorizations to be issued against Boyson and other accused in the Cato Manor case. That's on the basis of the PowerPoint presentation we dealt with. Paragraph 117, evidence has been provided to me by Advocate McAdam. See attached here to in evidence bundle annexure X, and that is an annexure. I'll continue, which is comprised of email exchanged between Advocate Mayema and Advocate Chauke on 28 and 31 March 2014. This email was also sent to Advocate Noko and pertained to mutual legal assistance with Greece in respect of a witness in the Boyson Cato Manor case. What is relevant for present purposes is that in the email of 28 March 2014 from Advocate Mayema to Advocate Chauke and Advocate Noko, Advocate Mayema proposed that Advocate Noko also had to be a part of the briefing session on Monday, 7 April 2014. Advocate Mayema noted that Advocate Noko would benefit from the presentation or any of the issues which were raised there when he stated that, or any of the issues which were raised there. He then stated that he was, however, unsure whether he had the authority to invite Advocate Noko to the briefing session. Advocate Chauke then replied to Advocate Mayema per the per the email of 31 March 2014, forwarding the response email to Advocate Noko that the latter was to be present at the briefing session of 7 April 2014. It would seem, therefore, given that Advocate Noko indicated in her affidavit, which is Annexure A to Advocate Broughton's bundle opinion, that Mr. Ngasana instructed her during a briefing session with the prosecution team to directly deal with the Boyson case as the DPP of KZN, that the briefing session referred to in the aforesaid email, Annex to Broughton's opinion, and the PowerPoint presentation dated 7 April 2014, which is Annex V to his opinion, indeed took place with the NDPP on such date. It is striking that even though Advocate Noko was included in the briefing meeting with the NDPP, her name did not feature in the PowerPoint presentation. This is further evidence that the Boyson prosecution up to that point was being controlled and directed by Advocate Chauke. It is also striking that Advocate Maima had to request from Chauke authority to invite Advocate Noko to a briefing session with the NDPP on the case, whereas all along he was de jure required to report to Advocate Noko on the case, since she was the DPP who had jurisdiction on the matter. Should I proceed, Counsel?
Who was the de jure person referred to?
Chairperson, as I read this, the de jure person with authority would have been Advocate Noko because she was the DPP in KwaZulu-Natal. And what Dr. Broughton is saying there is that according to the law, he would have been required to report to Advocate Noko. Whereas all along he was de jure required to report to Advocate Noko on the case since she was the DPP, and that was not the case.
Simply put, if my understanding is correct, that legally speaking, Advocate Chauke would then have been expected to report to Advocate Noko.
No, Chairperson, not Advocate Chauke, but it's Advocate Maema. If one reads from 4 lines from the bottom, it is also striking that Advocate Maema had to request from Advocate Chauke authority to invite Advocate Noko to a briefing session with the NDPP on the case, whereas all along, in terms of the law, he should have been reporting to Advocate Noko, which he wasn't doing. That was the point he was trying to make.
Maema.
That is correct, Chairperson. Advocate Chauke and Advocate Noko would be the same level as DPPs, and they would not be reporting to each other, Chairperson.
I understand. Thank you. Thank you for the clarity.
Let us then go back to the PowerPoint presentation. There are several documents there attached from page LO4, LO00887. Are they of any significance?
Before you do that, Counsel, we have exhausted 117, paragraph 117. And which document are you going to now?
I'm referring her back to the prosecution presentation, the PowerPoint, the document dealing with the PowerPoint prosecution presentation of 7 April 2014.
Just paging through this PowerPoint presentation, it seems to summarize all of the dockets in this matter. And the dockets, a number of pages refer to the dockets, and then it continues, and then from page 936, it deals with the enterprise, and that would be a requirement in terms of the racketeering charges. One is required to prove that there was an enterprise, and that is defined there, which I won't go into unless required to. And they say who the enterprise is. And then from page 939, they deal with the evidence linking accused one, and that is the end of the presentation.
I am lost.
Apologies, Chairperson.
PowerPoint bundle.
Bundle LO4, Madam Chair,
Hello, four.
LO00887, where the Katomana prosecution presentation document appears.
887.
Yes.
Yes, thank you. And Advocate Batoyi was reading from which page?
Chairperson, from 887, and then through to 935 seems to be a summary of the dockets at a high level. And then from 936, it's dealing with the elements to prove a racketeering charge, which you have to have an enterprise. And then it goes on to the evidence. One would have expected such a presentation to also include the pattern of racketeering activity, which is also required in terms of racketeering, but this presentation doesn't have that. It deals with the evidence in brief, and that's the end of the presentation, Chairperson. It appears that this was a presentation that was being prepared for the National Director to recommend another racketeering, the authorization of another racketeering certificate.
From 00936.
From the PowerPoint is from 00887.
Now, the point you are making now that it seems that that part seemed to have been intended for the purpose of authorization of a racketeering certificate.
No, to be clear, Chairperson, I said the entire presentation was intended to support a recommendation for the certificate.
The whole portion.
That is correct, the entire presentation. But from 936, it deals specifically with certain elements
The enterprise.
of a racketeering charge.
You may proceed, Counsel.
Thank you, Madam Chair. Let me then hasten to take you to paragraph 148 of Dr. Broughton's supplementary opinion. And the page is LO00228.
I suppose we are still on the point that you started at, the prosecutorial decision making.
We are still there, Madam
Are we
Chair.
still there?
Yes, we are still there.
Are you going to finish on that point, or is it still going to take us long? Otherwise, we have to adjourn for lunch.
I'm wrapping up. It's not going to take long. It will take about 2 to 3 minutes because I'm going to refer her to her affidavit and then we close it.
Yes, thank you. You may proceed.
Can you read that paragraph into the record?
Which paragraph, by the way?
148 in LO1, supplementary opinion of Dr. Broughton. LO1 bundle, page LO00220. 00220.
It will be helpful if you can speak louder. Speak to that mic.
LO1, page LO 00220. Can you read it into the record?
What is this document? It comes from
Still,
paragraph,
still forms part of Dr. Broughton's.
it's part of paragraph 147. Yes. I beg your pardon. 220, yes, paragraph 147 of Dr. Broughton's opinion. Yes.
One 147, Madam Chair, deals with date of meetings document.
I'm saying this paragraph, this portion that you're referring us to, flows from the previous page, paragraph 147.
Yes, the previous page contains paragraph 147.
Council, I'm asking you a very simple question. This part is part of paragraph 147. Nay.
The
Please.
part on page 220. Yes, it is. Before paragraph 148.
So you are referring the witness to paragraph 148?
Indeed.
That's why I am confused, because that top part quoted 19 June 2012 in quotation mark is part of 147. So we are going to paragraph 148.
That's correct, Madam Chair.
Thank you. Proceed, Council.
I asked that you read into the record paragraph 147. 147.
Paragraph 147.
148, rather.
Chairperson, paragraph 148 falls under a heading at LO 218, which says Advocate Chauke immersed himself in the investigations of the Boyson case. It appears to be where Dr. Boyson's pulling out certain conduct and to support that. I'm trying to contextualize 148, Chairperson. And then at 147, he lists various meetings that he attended to, and my recollection is that that was dealt with in evidence earlier. And then at 148, he says it is submitted that the above conduct by Advocate Chauke vis-a-vis the investigation of the Boyson Cato Manor case is not consistent with the DPP, who claims to merely put together and coordinated a prosecuting team to conduct a prosecution in another DPP's jurisdiction. This is besides the fact that Annexure B and J of Broughton's opinion reflect that Advocate Chauke attended court appearance in the Boyson case in Durban, including at the bail application. Indeed, even though he is the DPP of South Gauteng, Johannesburg, Advocate Chauke on 19 June 2012 had a meeting with the KZN Regional Court President, Mr. Nkabinde, to discuss availability of Regional Court Magistrate to hear the bail application, and that is footnoted. The question arises with respect how this could have happened where Advocate Chauke was not the DPP of KZN having jurisdiction over the case.
Thank you, Madam Chair. I'll then refer the witness to her affidavit, her bundle, and then wrap it up before we adjourn for lunch recess, whereafter we will proceed with the process
Thank you.
that she took when she referred the matter to the Office of the President. Go to paragraph 152, Advocate Batohi, of your affidavit on page 65.
I'm there.
Yeah, you may proceed and read it into the
Um,
record.
Yes, so just for context, Chairperson, so Advocate Ngasana, Mr. Ngasana, during his term did not authorize any racketeering certificates. And as per paragraph 152 on page 65, Advocate Sean Abrams, who had been appointed as the NDPP on 18 June 2015, issued fresh racketeering certificates for the prosecution of Boyson and members of the Serious and Violent Crimes Unit on 13 February 2016.
What we have been dealing with before paragraph 152, you were explaining the circumstances pertaining to that gap that you spoke about,
That is correct, Chairperson.
not covered in your affidavit.
That is correct, Chairperson.
You, Advocate Batohi, you said Mr. Ngasana did not reinstate the racketeering charges. And subsequent to that, Advocate Sean Abrams was appointed. Should one understand that you are saying because Advocate Mr. Ngasana did not reinstate the racketeering charges, he was then removed so that Mr. Abrams should be appointed? Because when you say subsequent to this, it creates a chain. Can I understand it to be linked to the non-reinstatement of the racketeering charges, or it's just the use of the word subsequent?
No, it's a use of the word because when I dealt with 152, I hadn't even dealt with the gap. So I'm reading as is, but there was a lot of publicity around Mr. Ngasana's appointment and removal from office. That's all I can say about that.
Thank you, Advocate Batohi.
Thank you, Chairperson.
Advocate Motlamunyane, are you wrapping up, or should we assume that you are going to then proceed from 153?
To now deal with the process.
I beg your pardon?
No, I'm mistaken. I'll take instructions because the next matter is the Mtluli matter. And the process deals with both the Mtluli and Boyson matters. I'll take instructions on that.
Yes, I want to know on this aspect.
On this aspect,
Have you wrapped up on this
it
aspect?
has been wrapped up, Madam Chair. The aspect that troubled Advocate Batohi together with me on the gap.
Yes. Before you go to Mdluli, and I'm just mentioning it now, we may have some few questions to clarify aspects in relation to this Boyson's matter before you go to the Mdluli matter. Thank you, Council. It's 2:30 now on that watch. Let's take an adjournment for 45 minutes to have lunch. We will reconvene at 3:15. We adjourn.
Madam Chair. Madam Chair.
Good afternoon, everyone. Yes, Council.
Yes, sorry, Madam Chair. I just needed to ask to be excused. Understand that the proceedings might go a bit further than usual today, in view of my preparations that I have to do still for my appearance tomorrow.
Perhaps this is then appropriate moment to place yourself properly on the record yourself. Did you earlier?
We did yesterday.
did.
We did place ourselves on record.
You did.
Yes.
Yes. I think we will have no objection in light of what you mentioned this morning in chambers. We understand that because of the division of labor, you might have to go and continue with other preparations elsewhere.
Thank you so much. Thank you, Madam Chair.
Thank you, Advocate Skosana. You are excused.
Thank you.
Council and Advocate Batoi, Advocate Skosana, Chauke rather, we intend to start and adjourn at 4:30. Madam, you are still under oath.
Noted, Chairperson.
Advocate Mushamunyane.
When we adjourned, Madam Chair, you indicated that you were having a few questions that you would like to pose to the witness, Advocate Batohi.
Yes, thank you, Council. Paragraph 156 of Advocate Batoi's affidavit summarizes, I suppose, the essence of the allegations against Advocate Chauke. Will it be correct to then have regard to this paragraph considered in line with the terms of reference under 3.3 and 3.1 and the sub-paragraphs there?
That is correct, Chairperson.
And bearing in mind that the answer could probably entail a legal principles regarding what constitutes evidence and what does not constitute evidence. That the common thread that runs through the terms of reference from paragraph 3, at least 3.1.1 up to the end, in relation to the Katomena matter, the Boyson's matter, until 3.1.1.5 is that Advocate Chauke misconducted himself in the manners described in those paragraphs. To summarize, by instituting the racketeering charges, I'm just paraphrasing that, supporting a decision to prosecute the accused, notwithstanding that there was no evidence, recommended to the acting National Director of Public Prosecutions whereas there was no evidence, sought to defend the institution of the racketeering charges in the review proceedings when there was no evidence to justify the institution of such review proceedings, instituted an appeal against the judgment of Judge Govan in the review case, whereas there was no evidence justifying the institution of the racketeering charges, and lastly, attempted to have the racketeering charges against Major General Boysons and members of the Kato Manor unit by reinstating the prosecution, notwithstanding that there was no evidence. I'm just paraphrasing those paragraphs. But the common thread is that in all those aspects in which he is alleged to have done certain things unlawfully, as you say in your affidavit, that thread is that there was no evidence. I'd like you to just take us there. Is it correct that there was no evidence whatsoever? Assuming, let us work on the assumption that Advocate Chauke took prosecutorial decisions. Let's even assume that he was authorized to do what he did in KZN in the Kato Manor. Let's work on those two assumptions. The question then remains, that being the case, can it safely be said, given the evidence that has been presented to us, put aside the legal opinions, but look at the evidence in the form of affidavits themselves, whether one can safely say there was no evidence?
Thank you, Chairperson. Chairperson, I would say that I can't say there was no evidence. I'll say there was insufficient evidence. Because if I may explain, Chairperson, if you look at the racketeering charges, one would have expected that let's assume the case proceeded. Well, not the case, let me rephrase that. Let me start again. In the assessment of whether the evidence met the standard of a reasonable prospects of a successful prosecution, one would look at what the evidence was. And in that particular case, one would have looked at all of the evidence in all the murder dockets. One would have looked at various pieces of evidence. And some of that would have been admissible as evidence. The question would be whether there was sufficient evidence to prosecute on racketeering charges. So that's my answer, Chairperson. You cannot say there was no evidence, but there was insufficient evidence to prosecute on the racketeering charges. And I hasten to add that all of the dockets, the underlying dockets, the murder dockets, were submitted to the DPP KwaZulu-Natal to consider each one of those dockets individually and decide whether there is any case, anyone can be charged from this group or anyone else from the group of the accused in the racketeering prosecutions. The DPP in KZN declined to prosecute all of the dockets except one, where the matter, I did testify about this earlier, where the matter proceeded to court in the one matter and the accused were acquitted.
I am more concerned about the standard of proof or the test, if any, applicable at the stage of a prosecutor deciding that on the facts before me, I am going to prosecute these accused persons. We are not yet at a trial where the standard of proof is beyond reasonable doubt. It is at that preliminary stage when you form a view as a prosecutor. And please advise me if I misunderstand, because I never prosecuted. With your experience and your knowledge, at the stage when a prosecutor seized with evidential material in the form of affidavits, that could include, and I'm just giving an example, that could include evidence such as the one contained in the affidavit of Colonel Ayer, among others, be it admissible or not at that stage, and others. What standard will a prosecutor be obliged to adhere to at that stage?
Chairperson, a
The
prosecutor...
standard of proof, by the way.
Yes, thank you, Chairperson. The standard of a prosecutor may enroll a matter where there's prima facie evidence of the commission of an offense. That is one of the standards. As the matter, when a prosecutor decides to prosecute a matter, it may be, let me explain, there's prima facie evidence and there's reasonable prospects of a successful prosecution, which are two different standards. Prima facie is, in my view, at a slightly lower level than reasonable prospects of a successful prosecution. You might have a case where a matter is enrolled and then there's further investigation done and the matter is reassessed, and then the standard, the amount of evidence increases and you reach the standard of a reasonable prospects of a successful prosecution. It doesn't mean that prima facie does not mean there's a reasonable prospects of a successful prosecution. But it's in my view, is a bit of a lower standard. But when you assess what the prospects of a successful prosecution are, which is the standard that we would apply in deciding whether to proceed with a prosecution, our prosecution policy guidelines give indications of what are the criteria that one should consider when trying to assess whether the evidence meets the required standard. And we did go through that earlier in my testimony. If I could be assisted to take the panel to that, which will
Yes, it will be helpful
assist.
if you can take
If
us
counsel or
to
someone can
the
assist
policy.
with the, it's in my affidavit. Just trying to
Well,
find.
the policies are under the folder, policies and directives.
I do also have it in my
Bundle
affidavit.
PD1. Counsel, if you have a copy or your team has a copy, you may assist Advocate Batoi with your copy. I have made markings in my copy, so I cannot borrow it to you right now.
Chairperson, I have in paragraph 24 of my affidavit,
On page 14, Madam Chair. of
on
the
page
affidavit.
14, I beg your pardon, yes. Paragraph 24 of my affidavit. We could still try to find the precise place in the policy, if the colleagues can try to find that.
I suppose your team
Yes.
will assist in locating those relevant portions of the policy. You can then proceed with paragraph 24, you said?
Yes, thank you, Chairperson. It says the decision to prosecute or not to prosecute must be made in accordance with the NPA prosecution policy and prosecution policy directives. The prosecution policy prescribes various factors that must be considered by a prosecutorial member of the NPA, generally referred to as a prosecutor, etc. I'll leave that out, when deciding whether to prosecute or not to prosecute. In essence, the prosecutor must have regard to the contents of the case docket, that is the prima facie evidence and statements contained in the dockets, as well as any version proffered by the accused in what is called a warning statement or a confession or any other statement made by the accused. The prosecutor must evaluate such evidence, taking into account all relevant factors, including how strong the case is for the state, whether the evidence is admissible, whether the state witnesses are credible, excuse me, whether the evidence is reliable, whether the evidence is available, and how strong the case is for the accused or the defense. Those are some of the factors to be considered, Chairperson.
Having regard to those factors that are referred to paragraph 24, will I be correct to say the prosecutor has a carte blanche to make that determination without evidence? He has that freedom, the wide freedom.
That is correct, Chairperson.
In a matter like this, shouldn't you direct us to those aspects of paragraph 24 that are suggestive of the fact that the prosecutor, Advocate Chauke, in this instance, if I may, did not apply his mind, did not take into account the relevant factors, didn't look at what was admissible or not admissible, what was likely to be credible or incredible, reliable or unreliable, etc.
Person, it would require me to go through the evidence very carefully. I should also indicate that the report of Advocate Chauke, the Chauke report that looked into this matter, sets out all of these issues in a lot of detail. We can certainly go through that. I don't want to miss out anything in trying to think about it as I'm sitting here, because this is a very complicated issue. So I do want to make sure that it's covered properly. It is covered there. My understanding is that evidence will be tendered as well by another witness that will go into the details of that matter.
I'm going to park it there, and perhaps my sisters have the questions flowing from these questions.
Right. Advocate Batohi, the questions that I'm going to ask you now will also be confined to an assumption that Advocate Chauke exercised the power that he had. And the focal point is about evidence, lack of evidence that is decried across that clause 3 of the terms of reference. Now, is it correct or not that in the course of exercise of the prosecutorial decision making within a directorate or the seat of court, as they have the seats, within that there would be teams of prosecutors who fall under the particular directorate?
That is correct.
That is correct.
They would be
yes.
prosecutors, and some
Yeah.
of them may be organized in teams,
Yeah, that's
in a
right.
division.
Yes, yeah. Now, is there a time where you find that there's a difference of opinion among the prosecutors about whether or not the matter should be proceeded to prosecution? There are such. I see you are nodding just for the
Yes, no, I
record,
thought you were
please.
going to continue with your question.
Okay.
You were not finished.
Yes.
Yes, there are
Yeah.
instances where there would be differences of opinion,
Yes.
and one would have to
Right.
consider the issue.
And there would also be cases, in such cases, where you find that there's a toing and froing between or amongst the prosecutors, one persuading the other, and ultimately they reach a point that, well, they will agree to disagree, and then someone, maybe senior, may come in to try to give direction.
Yes,
Does
certainly.
it
That
happen?
does happen.
Yeah. And out of that type of exercise, the cases would be processed to a point of prosecution and maybe prosecution to finality. Others, they would start with prosecution and halfway, because of the continuous assessment, there would be a recommendation that the prosecution be stopped and so forth. Am I correct?
On that point, it's quite rare. I don't have the figures, but the DPPs do decide whether to stop prosecutions. But from my understanding, that's quite rare. Once a prosecution starts, of course, there could be charges that may be withdrawn before plea. Before plea, yes, you could withdraw charges for various reasons. But once a plea is taken, then the charges cannot be withdrawn. The prosecution must be stopped. And that requires a DPP to authorize the stopping of a prosecution. Before plea, when it's withdrawn, a prosecutor can do that without getting the express authority of the DPP, because we deal with hundreds of thousands of cases in the courts. So just to make the distinction between a withdrawal before plea and a stopping of a prosecution after plea, which requires the DPP's authorization in the latter case.
Yeah, I understand the process quite well. The withdrawal of charges is against the stoppage of the proceedings or pursuing a particular charge. So the question that I had asked, it was about the issue of where you'll find that even if a recommendation had been made that a matter go for prosecution, because of other developments and also in the spirit of a continual assessment of the case, there are cases where there would be either a withdrawal before plea, of course, or a stoppage through proper processes of the proceedings, right?
That is correct. It can
Yeah.
happen, although I said stopping is more rare than withdrawal.
I understand that, yes. Now, if there is a decision, a prosecutor takes a decision that the matter be proceeded with, and during the course of continuous assessment, that a moment comes where a person is of the view that continuing with this matter could constitute a miscarriage of justice or undermining the Constitution. In such a case, when that happens, is there any judgment that is cast upon the prosecutor who then later comes up? And when I say prosecutor in this case, please understand me, I'm talking about the prosecution holistically, be it from the top to, yeah, that's right.
If the prosecutor had good reason in the first instance to enroll and charge, then of course things can change and charges can be withdrawn and there'll be no consequences. As long as the initial decision to prosecute was taken responsibly and there was sufficient evidence that supported that decision. That is very important. If there's the converse, a prosecutor, there was grossly insufficient evidence or no evidence, and the prosecutor enrolled it and then withdrew it, then of course there must be consequences depending on the facts of each matter.
But then who would arbitrate on the question of judging the decision of the prosecutor who could have proceeded with the matter? Who becomes the arbiter to say, but in this case, this was actually totally unreasonable and uncalled for, or this was justified even though the case is lost by the state, but there was justification? Who becomes the arbiter of that?
You could have experienced prosecutors in the NPA that could look into the matter.
And how does that happen? Does it happen just of the prosecutor or the DPP's, NDPP's volition? Or is it something that would be coming from somewhere where someone says, but we've got to look at this? And when I say that, I'm also looking at, there are cases where you find that there is just public outcry about a matter being proceeded with or not being proceeded with. Now, in instances where there are no even representations from the parties to the case, but there is a public outcry out there about how the matter went about, does the NDPP or the director have a standing of his or her own volition to look into the matter and make a judgment call as to whether there was in fact evidence of the threshold of exercise of prosecutorial decisions, and not the evidence there that we may talk about during the course of this discussion, which is at court level about 174.
Of course, if that happens, there is an outcry. The DPP would, in fact, look into the matter. Sometimes I find there's, media reports, etc. I would ask the DPP for a report to look into it and find out what the position is. So it would happen if that situation arises, that we would definitely look into the matter.
Right. Should the DPP's word or the outcome that is reported to you, because you'll want to hear from the concerned DPP before you can come in. Let's suppose it goes against the grain of what is being argued out there. Do you, as the NDPP, then step into the arena and satisfy yourself so that you can then come up with a judgment as to whether there was evidence in this matter, or not? And when I say evidence or not, it is in the understanding of sufficient or not sufficient.
Generally, I would ask for a report from the DPP. And depending on what the nature of the issue is, they would sometimes summarize the evidence in the matter. So it could happen that would be the case, that the DPP would send a report about a matter, summarize the evidence, and I would then decide whether it appears from the report that the correct thing has been done or not.
In your assessment of the DPP's report, does it ever happen that you, as the head of the institution, comes in and look into the raw evidence or raw information that is available in order to satisfy yourself as to whether the report should be accepted or not?
Generally, I would accept the DPP's report on this. If it's a matter of a review specifically, which is a different process, then there would be occasions when I would call for the dockets or the raw evidence, because that is a review of the national director. But generally, in the situation that you mentioned, I would generally accept the recommendation of the DPP with regard to what the position is in the matter.
Oh, let's go back to the standard. The standard required of a decision to either prosecute or not. We are in agreement, you and me, and I think it's settled law that there will be a standard for prosecutorial decision making, and there will be a standard for the court if the matter is now at court. That would be the normal, even though this everybody knows it's a 174, and so forth and so forth. The others, it's about assessment. Now, I think when my sister here, Sister Justice, was asking about the standards, you indicated, and please correct me if I'm wrong, you indicated that the standard required for a decision whether to prosecute or not, the standard is higher in respect of the prosecutors at prosecutorial level as against the proof that we want at court for the matter to proceed to another level that is beyond the 174 level. Is that understanding correct? And if my understanding is not correct, please just correct me so that we discuss on a common base.
No, thanks for that. I'm just the 174 level that you mentioned is confusing me a little bit, because a 174 is a discharge at the end of the state case. So I'm not sure how that fits into the standards as far as decisions to prosecute are concerned.
Yes, I'm aware that once it's the 174, it's a power that would be exercised by the adjudicating judge or magistrate.
After the state
Right,
case, that's
exactly.
correct.
But then, at the time when you were asked about the standard, I remember quite well my sister Justice asked about the standard of proof that would be required at different levels. Much as when we talk about the standard required, when it has to do with prosecution, it will be the prosecutor. When we talk about 174, it will be the presiding officer. But what we are talking about that standard, it's about evidence. Evidence prior to trial and evidence during trial. And there's a common understanding that the two, they remain evidence, but the only thing is at that time, who is the judge? Now, when it comes to prosecution, the judge there is the prosecutor. The judge that decides as to
yes.
whether, yes, is judging, isn't it?
Decision maker.
Exactly. None. Yeah, I say a judge. It's fine, you still judge. The judge to say this thing should go for prosecution or not, right? So here, the purpose of this discussion is just to address this issue of evidence. So I don't think it's necessary for us to pull hairs and say, but this is at court, the prosecutor has nothing to do with it. And then in this case, the prosecutor has something to do with it. We understand the boundaries of each. But then can you maybe just reiterate as to what is the standard of proof required for a matter to progress, to be subjected to prosecution proceedings, to go for prosecution?
So as I mentioned earlier, when the chairperson asked the question, a matter may be enrolled if there's prima facie evidence. And the standard, prima facie evidence, in my view, and there may be others that perhaps hold a slightly different view on this, is a slightly lower standard than the reasonable prospects of a successful prosecution. Prima facie is if you have, at the simplest level, if somebody says, look, he hit me, that's prima facie evidence of the commission of a crime. But when you add to that other evidence, for example, you have a medical report, you have somebody else that actually saw the assault, then it takes it to, you have a better prospects of a successful prosecution because it's not just the say-so of one person. So reasonable prospects of a successful prosecution is what we must be satisfied of when we decide to proceed with a matter to trial. So I hope I'm making myself clear.
I hear you, but I'd like to make it even just simpler, easier understanding. Oh, thank you. I beg your pardon. Right, thanks. Let's talk about, because, the issue of deciding whether to prosecute or not really lies in the contents of the case docket. Is it correct that there are times when, or instances where, the prosecutor would recommend that a person be charged, right, while the investigation is ongoing? That is correct?
Yes, that happens.
Yes, that happens. Now, once the prosecutor has decided that the matter be a progress to court while there is still investigation, then the prosecutor would then identify the gaps in the case docket on evidence while the matter already someone has been charged.
That's correct.
Yes. And then they will then write in the, what is it? OB?
Investigation diary.
Exactly. To the police to say, please do this, get this, and get that. Right?
That's correct.
And there comes a point when the prosecutor says, there is enough evidence, the matter can proceed.
That's correct.
And there are instances even where even after a person has actually pleaded to the charges, there is continuous obtaining of statements in order to beef up the case as and when the matter progresses.
That also happens.
Yes. And ultimately, a case that may have started as if it's not really a good case, with the passing of time and ongoing engagement, that case then gains strength.
That happens.
And then, of course, ultimately it will bring results. And results can be acquittal or conviction. It's still results.
That does happen.
So in actual fact, out of this discussion, we are agreed that evidence can be obtained or built up as the matter progresses in the fashion that I've just illustrated to you now.
That is correct, provided you had sufficient evidence to enroll in the first place.
Let me put it otherwise. If in the scenario that I'm painting, a scenario where you start obtaining, you continue to obtain statements, get more information, you write to them to say, get a statement of so and so and so and so. If that were not to be done, then that case will almost certainly not be successful in favor of the state.
It's very hard to answer in the abstract because each case has got to be decided upon on the evidence that you have. And sometimes, even though you don't have all the evidence that you want, you have sufficient that will meet the standard of a reasonable prospects. So it really depends on, but you must have sufficient evidence that would meet the standards. And you could, of course, get evidence that will strengthen the case beyond that, which is great for the case. But it depends on the circumstances of each case.
And the power to decide whether to prosecute or not will lie with the prosecutor or even the Director of Public Prosecutions, who then reads the docket and says, informs a view, reasonable view, that in light of this information that is in this case docket or a series of them, there is evidence. Much as when you look at it separately, there seems to be no evidence, but when you look at a series, a prosecutor can see, but this, based on this evidence, I believe, and truly so, exercising independence, exercising good faith, looking at all the, the tools that are provided through policies, through the guidelines and what have you, and say, I'm satisfied that we have a good case here.
So we must look at all the evidence in order to, all the evidence available before we come to that decision. But we certainly should not take the decision if we don't have evidence to prosecute in a case. But we have to look at everything to come to that conclusion.
Maybe just, I think we are saying the same thing.
I think we are.
Yeah, because you've outlined in your affidavit as to what is required for an independent decision to be made, a decision that must be made without fear or favor.
That's correct.
Right. Thank you for now.
Might I just follow up on these questions, because you will mention certain concepts which are worrisome to me. You speak of good reasons. You speak of grossly insufficient. And my sister Ramachacha asked you, who is the judge or the arbiter of what constitutes sufficiency or good reason? We earlier on in your evidence spoke about the policies which include, among others, the independence of prosecutors. It's captured in the Constitution, it's captured in the NPA Act and in your policies. You spoke about impartiality of prosecutors. Now, all these things that you are talking about, as I understand the processes, impacts upon prosecutorial discretion. And when you speak about a prosecutor having a good reason or having looked at entire evidence, and you, and I say you as the head, the NDPP, having to look at what this individual prosecutor has done to ascertain whether there were indeed good reasons or sufficient evidence. Will that in itself not have a chilling effect on the prosecutorial independence in the exercise of their discretions?
So, Chairperson, the idea of prosecutorial independence, we should not confuse the independence of a prosecuting authority from external improper interference. And that is what is guaranteed in the Constitution. It is the independence of the prosecuting authority from any kind of external interference. Independence, a prosecutor within the NPA is certainly not, you must exercise it independently in the sense that it should be without fear, favor, or prejudice, and we've dealt with those concepts, and then you take a decision. But it is not independent of the supervision and oversight of your superiors within the National Prosecuting Authority. So we need to have a clear distinction between the independence of the NPA vis-a-vis the supervisory role of seniors within the NPA to check on and oversee the work of others.
Yes, I understand that. I know that we are speaking about prosecutorial decision, exercise of discretion within. I'm not talking about outside interferences. Let's look at the scenario like here, where you as a head obtained opinions within, and you were given varied opinions by the senior prosecutors or the teams, some for, some against. Then you proceeded relying on the opinions by some of the prosecutors within who advised.
Mm-hmm.
Does it necessarily follow that those who advised you, whose opinions you seem to have accepted,
Mm-hmm.
were correct, as against those whose opinions you did not follow?
Mm-hmm.
At what stage do you then say, before the trial starts, when you have varied opinions within, do you then say, I will disregard the opinions of prosecutor G, but will take the opinion of prosecutor A?
Mm-hmm.
And then you decide, I will not prosecute. Probably in a matter that is of public interest, and the matter end up not being seen a day in court.
Mm-hmm.
Let's look, for instance, in a case of a rape of a minor child. And there is no direct witness. You have a word of probably a mother who was not there as against the word of the accused person. and you have evidence that this child was indeed raped, probably from the mother herself, but not a medical report. The prosecutor then decides, I'm prosecuting this case. The matter goes to court without the medical report, as it happens most of the time. And the medical report is obtained whilst the trial continues. If this prosecutor who has initiated the prosecution decided to prosecute in the absence of the medical report, would you say there was insufficient evidence, so much that you would say the prosecutor concerned misconducted himself by not obtaining all the evidence? And would you say that prosecution would have been unwarranted?
Chairperson, the facts that you sketched out, it's important because the facts of each case have got to be assessed. And it's very difficult to, and I'm trying to answer your question, because on the facts that you gave me, there's no problem with that. If there's evidence that the mother there's some evidence to show the child was raped, and there's sufficient evidence to enroll it, and then subsequently you get the medical that you also lead, there's absolutely nothing wrong with that. That can happen. But provided that at that initial period, there was sufficient evidence to enroll in the first place. And that's the point I make, is that the prosecutor must have had sufficient evidence to enroll and to proceed, and then the case can be further strengthened at a later stage.
What if a prosecutor, an individual prosecutor, decide to prosecute a particular case, and you as a head decides otherwise? And it turns out later that your decision was wrong, in the sense that it could have resulted in a miscarriage of justice by failing to prosecute a matter that ought to have been prosecuted, because we are all not perfect. We all make mistakes. What if it is you who makes a mistake as the head?
Of course, Chairperson, that is also possible. And as I mentioned, I think when I started off my testimony, that there are situations where reasonable minds will differ and you would have a different view of it. But I said this case is not one of those. So I don't want to come to this particular case again, but I agree with you completely. Reasonable minds can differ. You could have slightly different views. But, and as I say to prosecutors, that this can happen, and you must never be fearful of taking a decision, as long as you can justify it on the basis of what is in front of you. And there may be a slightly different view, we'll understand that. It's not a problem. But if you take a decision where the evidence is at such a low level that you should never have prosecuted in the first place, then of course, you need to answer for something. And if I, as the national director, take a decision where it's a ridiculous decision, there's just no evidence to support my decision, then of course I must be held accountable for that. And if necessary, an inquiry into my fitness to hold office should be held, because I should not make those kinds of decisions. I, as a national director or any prosecutor, must make a decision based on the evidence in front of you. Of course, and I keep saying, on the understanding that reasonable minds could differ, and we can't be dogmatic about this. There are other cases where one prosecutor would have a different view, and I understand that, and I say, look, I can understand, and we take a decision and we move on. But as a national director, I must make sure that when I make a decision, it is based on solid evidence in front of me. And if it's not the case, then I should be held to account.
My last question, and if you are not able to answer that, do say so. I'm going to go to this scenario before us.
Sure.
Bearing in mind that as at the time of this issue arising, there was a public outcry about the happenings in Katumena. It's all there in the record.
Sure.
So many people were killed. From the record, we are told that a number of police officers were involved. We were told on this record. They were at the scene or were found at the scene. And those murders resulted in a number of dockets or cases or charges, apparently against a number of police officials who were allegedly, and I repeat, who were allegedly involved in the shootings, where civilians ended up losing their lives. Now, in a matter of such public importance, where you have instances of some of the police officers themselves attesting to affidavits implicating some of these officers, will that not constitute evidence reasonably sufficient to lead somebody to taking a decision that in these circumstances, we will prosecute? I'm not sure whether I'm putting it the correct way, but you speak of the sufficiency of evidence. But I thought at that level, it will probably be the probability of this evidence being proved to be true, not the higher standard, whether you call it prima facie or not, but at that stage, the prosecutor exercises a discretion, as you correctly put it, on the evidence before him or her on this matter where there is no doubt that people lost their lives and certain suspects are identified. Whether correctly or wrongly, but we have a list of suspects, which in this case involves some of the police officers. Given the public outcry in KZN, and probably in Northwest, will this not be a kind of a matter which in the public interest will necessitate enrollment of the matter so that the matter can be ventilated in court? As my sister Ramachacha is saying, normally the case, you won't be having all the material at hand when you make a decision, but you have some witnesses already who in the course of the prosecution will bring more evidence because the investigation continues. My question is, will it not be in the interest, public interest, to have such a matter being ventilated in court?
Chairperson, you've said a lot. I'm trying to deal with all aspects of it so that I don't miss. I'll maybe unpack it.
Capture the last aspect.
I think there's some first aspects that were also important. So I think I have to try to deal with most of it because I don't want to leave anything out. I've been making some quick notes, so hopefully I do cover most of it. Chairperson, in most of these cases, and let me again say, I was not in South Africa. I was not here at the time. I'm talking about on the basis of what I have been, there's either evidence in dockets or what I've been told, and the evidence leader can consider it and decide whether to bring other evidence to support or to discount what I'm saying, that the police officers were on the scenes because in all of the matters, the accused were suspects in murder matters. And they were, according to the police officers, shot during the course of an operation to arrest them, suspects in murder matters. I stand to be corrected again, and that's why I say it's better to get the evidence from the dockets, that in one of the cases where one of the suspects were killed, there were 5 others on the scene that were arrested for the charges.
Might I, if you allow me, caution, because you don't have first-hand facts. You are not here. You were told, as we are all told. So we were told in the form of affidavits, as we are now told in the form of affidavits under oath, some of them. And remember, we are not in court yet. We are at that stage where we are making a determination whether a matter warrants prosecution. And you already at that stage have certain evidential material that may not be conclusive at that stage. It need not be conclusive, I suppose, but you have some evidential material. Say, for instance, if you look at the statement of Colonel Aya, Dondlo, all those statements. And you also look at the affidavits of some of your members, can't remember the names, which affidavits are evidence, not opinions. Now, when you assist with such a material, being a prosecutor, who ought to exercise that prosecutorial discretion? And you decide, this is such a matter that I should prosecute, given that scenario that I've presented. Will it then be appropriate for such a prosecutor to be charged with misconduct if it turns out later, maybe at the end of the trial, at 174 probably, where it is found that the evidence is not sufficient?
Chairperson, as long as the prosecutor has correctly assessed and analyzed the evidence before him or her, that is critical. And if you look at the factors that I mentioned earlier on, that a prosecutor must take into account when deciding whether to prosecute or not, factors include whether the state witnesses are credible, whether the evidence is reliable.
But how do you determine, I beg your pardon, how do you determine credibility at that stage? That is the space for the judge.
Chairperson, there might be issues that you are aware of at the time, or you may consult with a witness. In fact, we often consult with a witness. And if in that process they say things that are different, you have to take that into account. So these are the things that we must consider. Where they've made different statements, for example, that's an issue of credibility that prosecutors must consider. So, and if you look at, in this particular case, I understand that there were issues relating to credibility. For example, of Constable Iyer, Colonel Iyer at one point, and this was not part of my evidence, but there is evidence that there was an inquiry, and I know you'll caution me into saying too much, so I'm not sure how much I can say. This is a fact finding.
I still say, I beg your pardon, you say that was not part of your evidence. And I don't want us to go there, because you say this is your evidence and you say that was not part of your evidence. Let's not go there. Let's just try, and because I need your assistance here. This issue of prosecutorial discretion is important, because if prosecutors are not going to be independent, as you said earlier on in your opening address, and I think correctly so, that will have a chilling effect. So I just want us to understand, as I mentioned earlier, what does it mean when one says there was no evidence, as we see there being a common threat in the terms of reference, and yet we are presented with bulks of documents. Even in your affidavit, you refer to those documents that seem to contain evidence suggestive of the fact that there was evidence on which one could decide to prosecute.
Chairperson, I thought I clarified that earlier. The terms of reference we'll have to look at. But I was asked the question very specifically, and I said that perhaps no evidence is incorrect and that there was insufficient evidence to prosecute this matter. And I really want to emphasize, Chairperson, that it is so important that we take into account when we're deciding whether to prosecute or not, issues like reliability of evidence, availability of evidence, credibility of evidence, admissibility of evidence. So the mere fact that you have a statement is a good starting point, but after that, you have to make sure that as a responsible prosecutor, you apply your mind to every one of these factors to decide whether you can in fact rely on that evidence that is before you.
Madam Chair, if you allow me, with due respect.
Yes, thank you.
In a quest to help the tribunal in understanding what entails a prosecution or prosecutorial discretion, I would suggest that she refers to the prosecution policy as we have it here. We've got a page to which she can go. And I also would wish to refer the panel to page 34 of her affidavit, specifically in paragraphs 80 and 81, where she deals with case law relating to prosecutorial discretion. Maybe that might help in the midst of her, in a bold attempt that she's now embarking upon to try to explain the prosecutorial discretion. And may I also indicate that page 60 in PD, prosecutorial PD, it's policies and directives. On page 60 thereof might be of help. And if regard is had to what is stated there in specifically under paragraph A and B on that page. Paragraph B is on page 61, PD 00061. Paragraph A is dealt with on page PD 00060. What is contained therein might be of assistance. It might, to a very considerable extent, in my view, help everyone else to grasp the context within which prosecutors can exercise a prosecutorial discretion. Thank you, Madam Chair, for allowing us.
Thank you, Counsel. Let me just make one aspect very clear, that the reason why these questions arose is because of the terms of reference,
Says no evidence.
which are akin to a charge or a charge sheet in a criminal case. That is why I sought this clarity. But if the terms are couched in such a way that they suggest that in this case, on the assumptions that I've mentioned as regards Advocate Chauke, the evidence that has been presented to us, what does it mean that there was no evidence? That's where we started. And then the issue of the exercise of prosecutorial discretion then arose, emanating from Advocate Batoi's answers. But the concern is about the concepts, no evidence. If we are going to make this a determination of this case on the basis that there was no evidence, what does that mean? And that's where we are. That was my concern. Because somebody out there who reads these bundles and see the evidence with their eyes, and then they are told that there is no evidence. What does it mean that there's no evidence? That's where I started. And counsel, Advocate Batoi referred to, there must be good reason, there must be sufficient evidence, all those kind of concepts. But we need to get it clear as to, at that stage, what is the standard applicable? For a prosecutor to say, I am now in a position, independently, impartially, to exercise my discretion without fear, favor, or prejudice to prosecute or not to prosecute. That's where I am. The policies are clear. I wanted to direct my query to the terms of reference. So we can go back to the policies, but I don't think they address this pertinent point that I need clarity on. And Advocate Batoi has given us the answers that she could, I believe, to the best of her ability. And we need not pursue the point. We should accept her answers for what they are. I don't want us to go around circles and go back to the policies. We have read that. I just wanted her to explain in her own words, in her terms, her understanding as the head of the NPA, what it means in this case, that there was no evidence on which, or rather that warranted the behavior or conduct complained against.
Chairperson, may I respond briefly to that? Just if I'm understanding the chairperson said that the terms of reference is something that have to be looked at. It says no evidence. And the chairperson refers to lots of evidence that's been presented already. Chairperson, as I said, it should be insufficient evidence, but the terms of reference are, and this is my understanding, refers to that which was before Advocate Chauke when he made the various prosecutorial decisions. And the evidence that we have presented so far is evidence to show why his conduct did not meet with the standard. So that evidence is different from the evidence referred to in the terms of reference. I just thought there shouldn't be a misunderstanding about that. If there was, I could be mistaken about that.
Understanding about what?
What the no evidence in the terms of reference refers to.
There's no misunderstanding. We read it for what it is. That's why I need clarity from you as a lawyer. What does no evidence means in law when you make a decision, such as the one that has been taken by Advocate Chauke? And if so, what is the test? What is the standard? That's all that I was saying. That's all that I was saying, and needed clarity from you as to whether the test is higher, and you said the test is low. The standard is low, prima facie. And you spoke of good reason, grossly insufficient. And we need to get it clear as to what is expected of the prosecutors at that level. If you speak of no evidence, what does that mean? And that's the clarity that I require from you. And you have tried to explain what the concept means. You say that the use of no evidence is wrong. It should be no sufficient evidence.
Insufficient evidence, yes.
insufficient evidence. I beg your pardon. Council, we have gone beyond 4:30, and these are some of the issues that are needed clarity on when we adjourn. And it follows that you have exhausted the Part A as regards the Katomena matter, the Boyson's matter.
I would believe so. It has been exhausted.
But I
Unless
suppose if anything comes to mind later, it can be revisited.
Indeed, Madam Chair.
Just for the structure of our transcription and evidence, it means then you are ready to proceed on the second aspect, the Mdluli matter.
Yes, Madam Chair.
You will confirm that with us tomorrow morning when we resume.
Indeed.
Thank you very much, Advocate Batoi, and thank you very much, Council. This is the time to adjourn. We will start again tomorrow at 9 o'clock. Thank you. We adjourn.